Good morning, everyone, and welcome to the District of Columbia Court of Appeals. Joined this morning by Associate Judge Howard and Senior Judge Glickman. We have three cases set for argument this morning. Our first case is ERVIN Rogers versus United States. Counsel, are you ready to proceed? Ms. Walton is appearing remotely. Are you ready to proceed, Ms. Walton?
Yes, good morning, Your Honors. Yes, I'm ready to proceed and I would like to reserve 2 minutes for rebuttal.
All right, thank you.
So Mr. Rogers asserts that the trial court erred in denying his motion for a reduction of sentence under the Incarceration Reduction Amendment Act because the trial court misapplied Factor 10 of the IRA and failed to consider and weigh several relevant factors in its dangerousness analysis.
Ms. Walton, can I
Yes.
ask you if you could parse out for us how you think the trial judge misapplied Factor 10 in the decision of the trial court? He sort of lumps it together with two other factors in discussing the factors. And so can you parse out which part of that you think resulted in a misapplication of Factor 10?
Sure. There are two specific sections that I know I focused on, and I would like to direct the court's attention to. The first part was on page 6 of the trial court's order, under the section called merits, and then when he states what the 11 factors are. In that paragraph where it says as to factors 1, 9, and 10. The court states, the court observes that Mr. Rogers was not a juvenile when he committed the underlying offense, and that the offense required Mr. Rogers to choose to engage in the robbery, arm himself, and put himself in the situation that led to him shooting and killing Mr. Sales. So that was actually the trial court adopting the government's argument below and also quoting the government, the argument they made in its opposition. And significantly, the government had argued to weigh Factor 10 against Mr. Rogers in its motion. And then the trial court actually even quoted what the government stated and emphasized the fact that Mr. Rogers was a juvenile.
So how is that a misapplication under our precedent and under the statute?
Right. So there should be in Bishop v. United States 310A3D 629, this court found that Factor 10 must weigh categorically in favor of the movement in all cases, and that a trial court may not consider the degree to which the hallmark features of youth played a role in the underlying offense. And so the trial court not only emphasized that Mr. Rogers was a juvenile, it went on to state that to consider that he understood the severity of his offense and ultimately took responsibility as somehow weighing against Mr. Rogers. The IRA statute, as everyone knows, is applicable to everyone under the
Counsel,
age
if I
of
could
25.
stop you there to ask a question. I was on the Bishop panel and I recall, we may not have gone quite that far we say categorically as a general matter, but there may be some exceptions. As I look at this order, what strikes me is that it's a little more muddled than other orders I have seen in IRA cases. And it puts 1, 9, and 10 together, and it doesn't explicitly say, like some other orders do, this weighs in favor or this weighs against. Why couldn't we just view this as an appropriate analysis, at least under 1 and 9, where Judge Irving would have been acknowledging the relative youth of the individual under Factor 1, and then doing that Factor 9 analysis of the role in the offense, and leaving us either with 10 not really being covered that much, or if 10 was just in relation to the two?
Well, I think the government even agreed that it could have been clearer. But in Bishop, the trial court is instructed to weigh factor 10 categorically in favor of the move-in, and it just it's not clear here in Mr. Rogers's case. It is, I agree with the government that it is unclear. And so you have to go into the context and how the judge wrote the order. And there's the first sentence is addresses his age, and that's a factor, and it's fine to state, Mr. Rogers was 19, but it's not fine to then go and adopt the government's argument below that asked the trial court to weigh the factor against Mr. Rogers. And so that's what happened. I think that when you look at the government's opposition and then look at the trial court's order, it's clear that the trial court adopted the government's argument. And then that whole argument was to weigh factor 10 against Mr. Rogers, because there's a direct quote from the government.
Ms. Walton, to prevail on your argument, I think you have to show not only that the trial judge misapplied factor 10, but also that the error in doing so tainted or infected the judge's ultimate determination that Mr. Rogers had not carried his burden of showing that he would not be a danger to the community if released. And it's not clear to me that such taint is shown on this record, because the judge relied in coming to the conclusion on dangerousness on Mr. Rogers' behavior and his sanctions, the discipline that was required, his misbehavior in prison in the recent years. I don't know that I need to go into detail as to, on the record now, as to what that behavior amounted to, but that's what the judge was relying on in finding Mr. Rogers had not met his burden of showing non-dangerousness. How do you respond to that?
Well, Your Honor, Mr. Rogers does have a good record in many respects. And I think, as Your Honor knows, he's had no instances of violence in 10 years or more, no armed violence. He's done over 2,000 hours of programming. He has a release plan. He has a lot of support in the community. But the issue is that this factor 10 is very important, and that it was weighed against him. And if you look at the record, also the trial court made no mention of, when evaluating dangerousness, the trial court made no mention of his diminished culpability as an offender under the age of 25, the hallmark features of youth, and his personal circumstances.
That was 30 years. I mean, the judge, I suppose if the judge were here, he would say, that was 30 years ago. What I now have to decide is whether, if I release Mr. Rogers today, I can be confident that he won't be a danger to the community. And his rather lengthy and not de minimis record of discipline in the prison for misconduct, much of it of a sexual misconduct nature, I just can't make that finding. I mean, can we say that that determination was completely unreasonable?
Well, Your Honor, I think there is a over focus on these infractions that he's had, but it's only one piece of the picture. And there's plenty of evidence in the record showing that Mr. Rogers is rehabilitated and will not be a danger to the community. But
what
again,
about the sheer volume and number of the infractions and the recent nature of them? This is unusual in terms of the cases that we've seen on appeal, to have this number of infractions fairly recent and close in time to his IRA petition. And what the trial judge said that was interesting is that they seem to show that he has not to paraphrase, a disdain for authority that could translate into more infractions or legal violations when he is released, if he were to be released. How do you respond to that rationale from the trial judge?
Well, that's why we have 11 different factors in the IRA analysis. If we just focus on one single factor, perhaps for everybody who applies for the IRA, if we focus on one single factor and the one factor that was the worst for that person, then nobody would be granted relief under the IRA.
Well, but that's
this
what
is-
you're asking us to do, in a sense, is to ignore how the judge weighed the other factors and then how he ultimately weighed them all, including factor 10 in the dangerousness analysis.
Well, my argument is that under Bishop, that it is error. I mean, my argument boils down to the simple fact that under Bishop, it's error to weigh factor to get 10 against the movement, to weigh it against Mr. Rogers, and that is what the trial court did here. And that's
In Bishop, you may recall, our view was that we weren't sure, like there was more equipoise to the variety of factors. And we weren't sure that if factor 10 was weighed properly, that it may not change things. And so that kind of leaves us back in the same place right now. Like, well, what's kind of your best argument for how we get around the dangerousness here? Because we do have to get past the dangerousness point to even get to the interest of justice point.
Well, again, I understand the concern about the recent disciplinary infractions. But I want to focus on the lack of violence in Mr. Rogers' case. There has not been any infractions for violence. And so when we're talking about, this was a case of a young man, a 19-year-old, right, who was and he went to do a robbery and then he ended up shooting and killing somebody. And now he's been in jail for over 30 years. He's in his 50s. He does have these infractions, yes, but I think it speaks stronger that he has no infractions for violence in over 10 years and nothing for armed violence. And so when we look at this one factor, with the disciplinary history, we also have to look at in the context of how he has behaved in prison, and he has done very, very well in many respects.
Well, now it seems to me you're arguing the merits of the judge's determination that Mr. Rogers had not shown himself to be non-dangerous. Do we review that? When you frame the question in that way, is it a question of whether the judge clearly erred in concluding that Mr. Rogers had not met his burden? It's one thing to say that the analysis was infected in some way by a legal error. But your latter argument has been, well, I just don't think he's so dangerous. There wasn't a lot of evidence of his dangerousness. And I'm challenging the judge's determination that way. That sounds like you're asking us to say that the judge clearly erred in his evaluation of the evidence. It's a difficult standard for you to meet.
No, Your Honor, this is an abuse of discretion standard applied to the IRA analysis. That's pretty clear. I'm just attempting to reply to the questions about, the harmless error question. And in my argument, again, I would submit that that there was not harmless error here. And that we have to go back to the misapplication of the law. And the fact of the matter is that the trial court in this case did apply factor 10 and under the case law. And I understand Judge Howard was on the Bishop panel, and I appreciate your Honor's insight as well into your decision. But I still think that if you look at the trial court's decision here and you look at the portion of the government's argument that that the trial court adopted and quoted, it is obvious that there was a misapplication of factor 10, and that under Bishop that would require a remand with instructions for the trial court to apply factor 10 categorically in favor of Mr. Rogers.
All right, thank you, Ms. Walton. We'll reserve some time for our rebuttal argument.
Thank you.
Mr. Brock?
Thank you, Your Honor. May it please the court, Matthew Brock for the United States. Judge Irving did not abuse his discretion in denying appellant's motion for IRA relief. And considering the record as a whole, this court can be confident in the trial court's determination.
Can you focus us on whether or not and how the trial judge addressed factor 10?
Yes, Your
Did
Honor.
he misapply it? Did he not apply it? Go ahead. No,
The trial
words in
court
your-
weighed, the trial court acknowledged all 11 factors and specifically considered factor 10 in combination with all of the factors, but especially factors 1 and factor 9. And you can see that in the order. On page 6, the court recites factor 10, noting unequivocally that it counsels against lengthy sentences for both juveniles and for persons under age 25. And it does not categorize that by saying that it can be reviewed on some sort of gradient. And additionally, on the next page, the court further observed that the record indicated that appellant was likely susceptible to negative peer pressure and to antisocial behavior, and that likely played a part in his participation and his role within this specific offense, which is acknowledging how these hallmark features of youth may have played a part. And however, in this part of the order, or subsection B1, where the court lists the 11 factors, the court doesn't specifically apply weight to any of the factors. It's not until subsection B2 where the court does apply weight and where the court focuses almost exclusively on factor 3, and that is the appellant's behavior since his time in incarceration.
Doesn't it appear from the order that the trial judge weighs factor 10 against the appellant? And does that run afoul of this court's decision in Bishop?
Your Honor, it does not appear that he weighed factor 10 against appellant. Instead, he acknowledges how the hallmark features of youth may have played a part. And then to the extent that he is acknowledging the factor 10 requirement of considering an aging out of crime, he acknowledges how the disciplinary record, the lack of consistent programming demonstrates a lack of maturity and a lack of rehabilitation.
So
since his
counsel,
time
let
in
me ask you,
incarceration.
do you agree at least that the way it's written with 1, 9, and 10 there together, even if there is this acknowledgement, could be read in a muddled fashion?
Your Honor, as we acknowledged in our brief before the court, this certainly could be clearer. However, I would differentiate some lack of clarity versus an ambiguity. And even if there is some lack of precision in describing factor 10, this imprecision clearly did not sway the trial court's determination, as evidenced by its focus on factor
Before
3.
you go there, as we kind of, harmlessness, I think, would end up playing a part in this case, right?
Yes, Your Honor.
And so if we're talking about the harms, what harm would there be in sending it back for clarification from your perspective? Whether that was an outright remand or even a remand of the record or something of that nature.
So I think there would be two specific parts to that, Your Honor. The first is, as you said, the harmlessness argument, which we can get to. But other than that is the fact that we would argue that that runs contrary to this court's statement in Bishop, that so long as a trial court's order demonstrates that the court adequately considered each of the 11 factors, and then clearly states the critical facts and reasons supporting its dangerousness and interest of justice analysis, and those facts are supported by the record, then there is no abuse of discretion. And the trial court clearly went through the 11 factors and then clearly state what it saw as the critical facts being the disciplinary record and his behavior since his time in incarceration. And those facts are supported by the record.
Counsel for appellant argues that the facts that the trial court relied on don't really show dangerousness, despite the number of infractions while incarcerated. How do you respond to that? That they
Your
were
Honor-
not violent infractions, as I believe.
First, Your Honor,
that
yes, Your Honor. First is the sheer number is 120 violations. And first,
over the course of how many
Over the
years?
course, I believe of approximately 30 years at the time the trial court was reviewing it. However, we would note that from the time defendant entered incarceration age 19 until his 25th birthday, he accrued 2 violations, whereas he accrued almost half of the 120 violations in the 10 years preceding his IRA motion. This is someone who is showing a level of increasing violation as he has gotten older, not someone who is maturing out of crime.
How does that, if you could speak to the violent nature or dangerousness of what these infractions represent when they
These-
were not technically violent infractions?
Many of these infractions are of a sexual nature. Many of these interactions are directed at female staff, and these interactions or these violations are not de minimis. They are not simply a disobeying an order. They are actions which, if committed outside of incarceration, are criminal actions that could be prosecuted. And indeed, there are not only of the sexual nature, but there was also charges of possession of a dangerous weapon, introduction of alcohol or drugs into the facility, threats to stab staff members. These are actions which, if not specific actions of violence, are threats of violence or lead towards violence. And again, because of the sheer number, these actions which are engaged towards staff members, he expressly before this trial court acknowledged that many of these were actions he took in response to perceived mistreatment and perceived by staff members. And that underscores his lack of ability to comply with authority in perhaps the most structured environment he could be in at this time. And so being released into a very unstructured environment, how would he respond? And that is clearly demonstrated within the trial court's order, where he finds that the sheer number of infractions prohibits a finding of non-dangerousness, regardless of the other 10 factors.
Thank you.
And I had started to mention before, even if this court does find some lack of precision, because of the sheer number and the trial court's examination of the factors in B2, this court can be certain that on remand, the trial court would have the same determination. And therefore, any error would be harmless.
What's the standard of review for determining whether the error is harmless enough that we can sustain the trial judge's decision? In other words, assume that we are persuaded that the judge erred in addressing factor 10.
I would point this court towards its decision in Griffin v. United States, 251 A 3rd 722, where the court considered it as a standard of plainly having no effect on its decision.
At what level of confidence do we have to have?
I do not have that specifically in front of me, Your Honor, but I can submit a letter to the court with the specifics on that.
I beg your pardon? I didn't hear the last thing you said.
I can submit a letter to the court answering the court's question. And unless the court has any further questions,
I don't think so.
we would simply ask the court to affirm Judge Irving's order.
All right, thank you.
Thank you, Your Honors.
Ms. Walton, you reserve some time for rebuttal?
Yes, thank you. Quickly, Your Honor. I'll just go back and reiterate the fact that this case really is a case that needs to be remanded to the trial court for with instructions to apply factor 10 categorically in favor of Mr. Rogers. And
Ms.
as
Walton, I'm sorry
yes.
to interrupt you. Did you think a remand here would be mere form over substance, or what's your basis for thinking that the remand would alter the outcome potentially?
Well, because if the judge misunderstood or just misapplied the factor, we don't know how, if the judge was instructed to weigh this factor categorically in favor of Mr. Rogers, we don't know if he does that, he may change his calculation of dangerousness. We just, at this point, we don't know how this affected his ultimate ruling, because in his dangerousness analysis section at the end, again, he does not mention factor 10, the diminished culpability, the hallmarks of youth, none of it. And so the way that what we have before us is just not a clear order that clearly applies the law correctly. And under the abuse of discretion standard, then it would be appropriate to remand this case and have the trial court issue a new order. Now, he may, he may ultimately come out on dangerousness the same, but sitting right here, right now, we don't know that, and we don't have an order that makes it clear that the law was followed in this case, and that is the problem.
Ms. Walton, I'll tell you that the difficulty I have with your position, I want to give you a chance to respond to this, is that even assuming that the trial judge categorically erred under Bishop in addressing factor 10, which I don't really think is that clear, but let's just assume that for the sake of argument. I don't see anything in the record that suggests to me that that error impacted the impacted the judge's determination that that Mr. Rogers had not met his burden of showing that he was not dangerous. And if that is so, then I'm inclined to think the dangerousness determination was a reasonable one and it should be upheld. That's why I started out by asking you about in what way do you think the dangerousness determination, this man remains a danger now, 30 years after whatever happened in the past, was impacted by any errors that the judge may have committed in addressing factor 10.
I understand, Your Honor, and I don't have much more to add at this point, except that what I see is a clear misapplication of factor 10, but which could also be seen as, an unclear ruling, that this really infects the whole dangerousness determination to the extent that this case really has to be remanded for clarification and for this factor 10 to weigh in Mr. Rogers' favor. And at that point, the trial court will need to go over the factors again and weigh them appropriately, as per this court's holding in Bishop. And so again, I ask, I don't know if that answered Your Honor's question, but I again just ask, respectfully request this court to remand this case to the trial court.
Thank you.
Thank
All
you.
right. We'd like to thank both counsel for your briefs and argument today, and the case will be taken under advisement.
Thank you.
Thank you, Ms. Walton, for joining us remotely.
Thank you.
All right, and you're free to exit the or welcome to continue watching. All right, our second case this morning is In re Amanda Haynes and Fernando Compamore Sanchez. Counsel, just let us know when you're ready to proceed.
Good morning, Your Honors. My name is Sarah Fink, and I represent Respondent Amanda Haynes. I'd like to please reserve 3 minutes for rebuttal.
All right, good morning.
Today, we are asking the court to apply the legal framework established in re Dobby and make 3 findings. Number 1, Ms. Haynes subjectively did not believe the fact of Morales' debrief was exculpatory. Number two, that belief was reasonable. And number three, even if you find she violated Rule 3.8E, there should be no sanction because the fact of the debrief was not material. Now, you can make those findings and also believe that based on the information we have today and the standards today, Ms. Haynes should have known that that information was exculpatory. You can also think that Ms. Haynes and all the other prosecutors who looked at this evidence were wrong, but that does not mean that they were unreasonable.
May I ask you a preliminary question that I find myself uncertain what the answer is? The hearing committee in this case found, it's a factual finding, that Ms. Haynes knew that the evidence was that the debriefing, the past debriefing, was giglio evidence, was impeached Morales. The board on review rejects that finding and concludes only that, well, any reasonable prosecutor would have known it, but we don't find that Ms. Haynes was aware of it. Now, that doesn't make too much of a difference in terms of whether there was a violation of Rule 3.8, but at least to my mind, it makes a difference as to what the appropriate sanction is. In the first, under the hearing committee's view, we're talking about bad faith, whereas under the board's view, we're talking about good faith, a good faith mistake, and not an excusable one, but goes to the question of what kind of sanction is appropriate. So now it comes to us, and
Judge Glickman,
do we make an?
I apologize for interrupting, but we have a minor technical issue. And since we are streaming, I just need to pause and ask you both to hold those thoughts.
Sure.
Excuse us.
That's easy for you to say.
Thank you. Thank you. All right. Sorry about that. Now, would you repeat everything again? No, just.
Try to keep in mind. So the question for me is, well, now that it's before us, what do we do? Do we defer to the hearing committee's determination, to the boards? Do we make our own determination? Ab initio. What do we do with this disagreement?
This court can make and should make its own determination. So on the first point,
Its own factual determinations or legal or both?
its own determinations as to ultimate fact, and I believe the facts that go to Your Honor's question are ultimate facts, those facts being,
Gee, is that really right? Whether someone actually knew that or merely should have known, do you think that's an ultimate? It makes me a little nervous. I didn't hear the witness testify. I have to look at this from a, just a paper record.
I do, because the way that this court looks to the board findings is it looks to legal conclusions, which of course are de novo review, and then ultimate facts. And it explains ultimate facts are things that answer that legal question. And here under Dobby, the way that the court explained how we have to conduct this analysis, the first question under the state of mind and intent is whether the prosecutor whether they actually believed that the information was exculpatory. So that is an ultimate fact. The answer to that question, if the answer to that question is yes, then we have the answer and 3.8E is violated.
So in other words, it's a sort of a sufficiency of the evidence analysis. Did bar counsel prove, the disciplinary counsel prove by clear and convincing evidence that she knew? That's the standard we apply here.
That's right, Your Honor. And to your question about this,
And then if we say no, if our answer to that is no, then we would presumably say, now we turn to whether, as a matter of law, on the given what these facts are here, most of them undisputed, she should have known.
that's right. That's right. And we look at that with the second factor under Dobby is whether she should have known. And here, under the record, it is clear that it was reasonable for her to think that it was not exculpatory.
Well, what do we make of the hearing committee testimony or testimony that she gave where she uses the language, she wanted to take the sting out of any potential information, which is why she questioned Mr. Morales about whether he had cooperated with the government in any other matters before. Would a statement like that tend to indicate that she knew there might be some exculpatory or impeachment value to the bare fact that he had been debriefed before? And couldn't that certainly lead to a finding that she knew or that she should have known?
So just to make sure the record is clear, Ms. Haynes did not ask during trial. She never asked Mr. Morales whether he had debriefed before. And the whole reason for that is because as she
She
also
makes this statement, I believe, in the proceedings before the hearing committee, correct?
She does. She says that when she was speaking with him before trial, that was a question that she asked him. However, once she had his answer and she ran down information about Morales, she determined that there was no sting that needed to be taken out. And that's why she decided not to ask him about it at the trial, because there was no sting there.
Well, but she determined that there was no sting to be taken out. Does that run contrary to this court's decision in Zanders, where we say that that kind of determination should be left to the defense in trying to decide how they might want to use something that's potentially goes to credibility or could potentially be exculpatory?
So, Your Honor, that is consistent with Zanders. In Zanders, the court found that if information is on its face exculpatory, then it needs to be disclosed. And the court was dealing with that sort of information. For example, the fact of a government witness being a cooperator or an eyewitness to a murder saying that they then didn't remember what happened. Those are the cases that are cited to in Zanders. Whereas here, it's simply the mention of a debrief, which on its face, Ms. Haynes did not see as inconsistent at all with Mr. Morales saying he hadn't testified before and that he hadn't come forward against people
Well, suppose
before.
we were to agree with the hearing committee's finding that she knew it was exculpatory. Where does that leave us in light of the fact that this happened prior to this court's decision in Klein, where we said exculpatory as well as material information that's not disclosed violates Rule 3.8?
Right. So I'll conceive that if you find that you knew, that's not very good for Ms. Haynes. And then we would have to move to what the sanction is under 3.8E. But as Your Honor points out, under Klein, the court decided that for any conduct that predated Klein, and remember, we're talking about this case was 15 years ago, right? This is back in 2010. Certainly predates Klein, that in order for there to be a sanction, it has to be that the information at issue was material to the outcome of the case. And here, the fact that Morales had debriefed before had absolutely nothing to do with whether Mr. Guandique had murdered Chandra Levy.
Well, I wonder if that's true. I mean, from the prosecutor's point of view, I guess, there is a problem with this witness. Namely, he's first coming forward with a report about Mr. Guandique having confessed to him some years after the confession occurred. And that seemed to be something that required explanation. The explanation was, well, he had gone from being a saint to being a sinner to being a saint, that to use the language that was employed. He had had a recent change of heart. And prior to that change of heart, he never would have talked to the government about anybody doing that. Indeed, he could get killed for doing so if it was found out. So that was a pretty good explanation. But and one rather thinks that a prosecutor with Ms. Haynes' experience would have appreciated that issue, certainly. And here we have this nice explanation, which is undercut by the fact, as it turns out, that he had been debriefing with the government over a considerable period of time. You don't think that's something a prosecutor would appreciate as being material?
So I have a couple points on that. First, the question is whether the information is material to the outcome in the case, right? The question isn't whether, it's something that a prosecutor should have known, or that maybe the defense would have wanted to know. And PDS did cross Morales extensively, including on his delayed reporting. And then it's also, it's important to look at this as what is the evidence that we're analyzing as material. It's the fact of Morales's debrief. It is not the fact that, they learned 2 years later all of these things that he had done and that he had told on others in California. That is not what was known at the time. And so we have to look at this again as 2010. And this is a time where you can think that based on everything we know now, including everything we know about Morales, that Ms. Haynes was wrong, and that she should have known. But going back to 2010, 15 years ago, we didn't have that information.
Well, going back to 2010, when there was the disclosure of the page 2 and 3 of the Morales letter, but based on the hearing committee's findings, I know there's some dispute, based on the hearing committee's findings that page 1 of the letter was not disclosed. And it's on page 1 of the Morales letter where the debriefing is mentioned. You say you can't go look back in hindsight now, but it seems like had page 1 of the letter been provided to defense counsel at the time, the very first question would have been, what was the debrief about? And let's look into that. And so it seems like a whole line of investigation was precluded by not disclosing page 1 of the letter along with the rest of the letter at the time, which I think may undercut the argument that this is all hindsight that we're looking at now. I mean, it seems to me that that would have been a piece of information that any defense counsel would have wanted to know and to at least try to investigate along with the other lines of cross-examination that were followed.
So a few points on that. First is that we are asking this court to reverse the finding that page 1 was not disclosed. The evidence on the record at best is 50-50. And
Well,
it does.
That's what the Justice Department investigation determined, that there wasn't enough, there was evidence showing that it was disclosed and evidence showing that it wasn't. So during that, in that report, they find inconclusive. But the hearing committee found conclusively that it was not disclosed. And so how do we overturn that finding?
Sure. So you can overturn that finding, one, looking at it as an ultimate fact, or even if you're looking at it just as a fact, there is not substantial evidence that actually shows
We had
this.
several witnesses testify that that they never received page 1. And then we have sort of inconclusive testimony for on Ms. Haynes' behalf from witnesses saying they don't know for sure whether it was disclosed. So it seems like that's a pretty sufficient basis in the record to show that it wasn't disclosed in the record before us right now.
Well, even if looking at it that way, then, you would need to look at the difference between an accident and something intentional. And there is nothing on the record to indicate that there was any intentional withholding of page 1 as Jenks. A couple things to look at. Number one, it said page 2 and page 3 on the top of page 2 and 3. It was screamingly obvious that there was a page 1. And if they wanted to hide it, they probably should have gotten rid of the page numbers 2 and 3. Also, ODC said in its closing argument in Dobby that if you want to know what prosecutors are really thinking and what's going on, don't look at their briefs, don't look at what they're arguing, look at what they say to each other. And here we had the benefit of seeing everything they said to each other because of the post-trial investigation, because of OPR, all of their emails have been looked at. And there is not a shred of evidence that actually shows that there was some attempt to withhold this page 1.
Well, in Dobby, the court talks a lot about how you look at intentionality, what we mean in this situation. And it's not necessarily the intentionality to hide something, but it is the deliberate act of doing or not doing. And here, arguably, it's the action of not providing page 1, not necessarily going on to say, and it was done for malfeasant or nefarious reasons.
Right. So in Dobby, the first step is, well, was the information disclosed? And let's just say for argument's sake that page 1 wasn't disclosed. The next thing you have to do is ask, well, did the prosecutor actually think it was exculpatory, right? And if they did think it was exculpatory and purposely withheld it, well, that's bad faith. But if it was not, if they didn't think that it was actually exculpatory, then under Dobby, you move to the next question, which is, would a reasonable prosecutor have thought that it was? Now, if you find that a reasonable prosecutor should have thought or would have thought that it was exculpatory, but that the failure to disclose was an accident, then that is not a violation. That's what Dobby said in finding that part of what was at issue in Dobby was a 3.8E violation, and the other part, the faxing error, was not a violation because that's an accident. So if we're going to say that accidentally page 1 wasn't turned over, then that's different than saying there was this conspiracy to withhold this one page, which also just isn't consistent with how Ms. Haynes handled her disclosure obligations generally in the case. If she was going to withhold a piece of evidence, this mention of the debrief really would not have been the piece to withhold. Look at all of the truly exculpatory and evidence that she disclosed. She disclosed DNA of an unknown person on Miss Levy's body when she died. They disclosed flaws in their investigation. They disclosed other leads. They even went so far as to disclose any hotline tips that came in.
Am I correct that the full 3-page letter, including page 1, was disclosed or submitted as an exhibit in the grand jury testimony?
That's correct. That's correct, which is certainly inconsistent with some conspiracy to withhold that information. And then looking at how Ms. Haynes handled the Morales evidence generally. So when she heard about the debrief, she didn't just take him at his word. She ran it down, just like she did with any other witness she would do, just like with any other prison witness. She checked the court docket to see if there was any indication that he had cooperated before. She checked the prison inmate quarters history to see if he had been housed with Guandique at that time. She even went so far as to pull all of the CNN tapes that had played in the prison that Morales was at the time to make sure that he didn't get the information about the confession from CNN. And when there was information about Morales to disclose, she disclosed it. She disclosed that he had asked for a prison transfer. She also disclosed that he asked for witness security for his family. And this is consistent with all of her disclosures. For other prison witnesses, when she looked on the docket and saw that one of them had some sealed records relating to mental health, one was a Rule 35, and she disclosed that. So when you look at all of her conduct, it is clear that she did not think it was exculpatory, and also that was reasonable. If I can, I know that my time has elapsed. I would, like to talk for a moment about the standards at the time and the reasonableness, but I understand if your court would like to.
That's fine. Mr. Randolph is going to argue as well. Okay.
Yes, Your Honor. We had agreed that disciplinary counsel would go next.
Okay.
Should I continue?
Mhm.
Okay. So, the second prong, of course, the reasonableness, and I'll just restate that you can think she was wrong, but just because something is wrong, it doesn't mean that it is not reasonable. So this is distinct from Klein, right? In Klein, the prosecutor there said, no, I don't think this evidence is exculpatory. Then when other prosecutors took over the case, they all came in and every single prosecutor who took over that case said, what are you talking about? AUSA Klein, this is exculpatory. And the court found it instructive that all of the prosecutors thought that. Well, here, the court should find it instructive that none of the prosecutors thought that. That includes the trial team. That includes the post-trial team, which was made up of close to 10 people who looked at 95 boxes of material and went through everything that the prosecutors had, exchanged amongst themselves and in the case. It also includes OPR. And then, when you look at the standards in 2010, again, different than what is today because standards have changed and evolved over time. But looking specifically at Judge Fisher and what Judge Fisher ordered in that specific case, Judge Fisher explicitly said that it is other it is materially inconsistent statements that need to be disclosed 2 weeks before trial. He also said that this information is for PDS to use at trial, not to investigate at trial. And finally, if you do find that there is a Rule 3.8E violation, I've explained why under Klein there should be no sanction. To explain why, it was not material, PDS was able to effectively challenge Morales's credibility. They called 3 witnesses to challenge his credibility. They asked him questions on cross about his cooperation, about his plea agreements in the past, about his criminal history. And the government also had other strong evidence. While Morales was an important witness, he wasn't their only piece of
Well,
evidence.
but I guess how do we weigh in this, that the government ultimately withdrew the indictment based on some of the post-trial motions and litigation effectively voiding out any conviction?
So that's exactly right, that all came from what was learned post-trial. That is distinct from the debrief. There was no dismissal of any indictment because of the fact that Morales debriefed. It was, one, they withdrew their opposition to the motion of the new trial because of information that was learned later, which again is not what we should be looking at right now for this analysis. And also when they ultimately dismissed the indictment, that was because Morales had been recorded telling somebody basically that he was going to commit all these other crimes and his, vengeance he wanted to take against other people, which had nothing to do with the debrief.
Let me ask you one other question. What about the Rule 8.4 violation? That can we still find an 8.4 violation if we do not conclude that there was a 3.8 violation?
If you conclude that there was no 3.8E violation, no, then there is no 8.4D violation. And disciplinary counsel said in their closing arguments at the hearing that 8.4D rises and falls with 3.8E. Now, I don't concede that if there is a 3.8E violation, there is an
I think
8.4D.
that's the actual question, but.
Oh, I'm sorry, was that?
No,
I apologize. So with that, and well, the answer is still no. And the reason for that is because under Dobby, they did find an 8.4D violation, but that's because there was a finding of dishonesty. Now, there's not even a charge of dishonesty here, and there's no finding of dishonesty. And 8.4D allows for the possibility that there are mistakes that are innocent in character. And I think that if you do find that 3.8E was violated, it had to be innocent in character.
And what about 1.6 violation, which Ms. Haynes essentially admits or concedes?
Yep,
What
Ms. Haynes.
should any sanction for that violation alone be?
Ms. Haynes did accept responsibility for that immediately. Just to kind of put that in context, she was sort of venting to her very serious boyfriend at the time about interpersonal issues that were going on in the office. She shouldn't have done it. But she accepted that responsibility. Nobody even knew about it and what the content of that was until ODC put it in the specification of charges. The sanction for that should at worst be an informal admonition. I mean, again, it happened 15 years ago. And I would like to say, Ms. Haynes this has ruined her. She has suffered immensely from this. She is no longer a prosecutor. She can hardly stand to, be in these proceedings because it just hurts her so badly. So she has suffered enough from this.
Further questions? Thank you.
Thank you.
No, I didn't ask about rebuttal time or anything. And I don't recall if you requested any.
I had reserved 3 minutes.
Thank you.
Thank you.
May it please the court, Hamilton Fox to the Office of Disciplinary Counsel. I want to address, if I may, 3 issues. The first is Mr. Campomore's responsibility in these matters for violating Rule 8.3E. The second is the issue of the extent of Ms. Haynes's knowledge, which came out in response to Judge Glickman and the Chief Judge's questions. And then third is the question of sanction. With respect to Mr. Campomore, the Dobie case laid out 3 elements for a violation of Rule 3.8E. We just run through them and then I'll try to explain how they apply to Mr. Campo Moore. The first is that the evidence is withheld, in this case, the debriefing, must tend to negate the guilt of the respondent. The court used the shorthand phrase of exculpatory information, Dobie. The second is that Mr. Campo Moore must be aware of the prior debriefing and that a reasonable prosecutor would know that it had to be disclosed. And the third is that he must have intentionally failed to disclose it. And I would submit to you that what that really means in the context of Dobie is that it was not an accident. Now, that causes me to pause for a moment and remind the court that we're talking about here is the withholding of Brady and Giglio information before the trial. In the argument that you just heard and in some of the briefs that have been submitted, there's been discussion about whether this information was disclosed as Jenks material mid-trial. That's not what the charge is in this case. The charge is that they did not disclose it in advance as they were required to do by Brady and Giglio. And when you hear arguments about intentionality, you need to keep in mind that we're talking about is the intentionality of withholding this as Brady material in the pretrial disclosures. Now, let me go back to these issues. First, was it exculpatory? As the questions that your honors have already asked indicated, they had a problem with the fact that Mr. Morales waited for almost 3 years before he came forward. And while there was discussion that Ms. Haynes reviewed the CNN tapes, in the letter that was sent, the so-called Zaldivar letter, they indicated that Mr. Morales had seen on CNN that Mr. Guandicki was the prime suspect at the time. So how do you explain that he's not just coming forward to implicate somebody based on this information? And the explanation that was consistently given was that he had had a recent change in outlook. I say saint to sinners too, or sinners to saint too, but the sinners to saint rationale. And the debriefing was inconsistent with that. And Mr. Campo Moore.
Can I stop you on that point? If I
Yes.
may, I hate to interrupt, but when you say the fact that there had been debriefing at some point in the past was inconsistent with the sinners and saints rationale. I mean, maybe I'm naive. It's been a long time since I practiced, as a defense attorney, but it's not obvious to me that it's inconsistent.
Well,
And evidently, I think it's probably fair to say it was not obvious to Ms. Haynes and Mr. Campo Moore.
well, I will come back to that. I specifically want to address that obviousness to them, but I think it is obvious when you, in the context of how they determined right from the time of the grand jury on to present this
The
witness.
sinners and saints, yeah.
And at trial, Ms. Haynes elicited testimony from Mr. Morales that said he would never have, this is the first time he had come forward. He had never would have considered doing that before because he had this thug mentality. That was the phrase he used, and that he didn't even know how to do it. And that's just a lie. I mean, he knew how to do it because he had done it before. And just to go to another point that I was going to get to later, but when Ms. Haynes was preparing him, she elicited the fact that this debriefing occurred while he was a prisoner in Atlanta, federal penitentiary in Atlanta, to state law enforcement officers from California. Now, she's an experienced prosecutor. The state law enforcement officers in California weren't just hanging around the Atlanta penitentiary they had to get there somehow. Somebody sent them a signal.
Well,
So,
Mr. Fox, you said, not to jump right in the middle of your explanation, but you prefaced everything you're saying now by saying it was obvious from the time of the grand jury to trial. But at grand jury, the entire letter was introduced into evidence, including page 1. Is that correct?
The entire, yes, but.
Doesn't that undercut?
No,
the argument of-
there are 2 points about that.
Okay.
The first one is that, yes, it is true, the entire letter was attached and made a grand jury exhibit, okay? But the information on page 1 about debriefing was not discussed. That was not brought out. The second point is there was testimony in this case that it was the policy of the U.S. Attorney's Office when they produced as they had to, as Jenks material, the grand jury transcript of Mr. Morales, to include the attachments, but they didn't include that attachment. So I don't think that gets them off the hook. They attached it, they did put it in, but it wasn't further disclosed, and it certainly wasn't further disclosed to the trial team.
If we conclude, I take it that if we conclude that this was materially exculpatory or impeaching Giglio evidence, but we conclude, if it is up to us to conclude, that like the board, that Ms. Haynes did not realize it, that she withheld it in good faith, and Mr. Campo Amor too, for that matter. As I said earlier, that affects our judgment as to what the sanction ought to be.
Well, so let me go to that. I
How
was
do you
going to get
feel
to that
about
later, but
that?
let me go to that right now. Here are the facts that the hearing committee found. One thing you have to keep in mind is the Brady disclosures were made on October 4. Ms. Haynes had never even spoken to Mr. Morales by October 4. So she made that decision without even talking to him. First time she talked to him was October 5 in Mr. Campomore's presence. And one of the things that they did on October 5 was they confronted him with the fact of the debriefing. When he came forward, and it's in her notes, and this is the pulling the sting argument that the chief judge alluded to when she was asking the question a moment ago. So they knew it was inconsistent because they bring out the fact he'd never done anything like this before again, and then they confront him with it. And in fact, there was a second session in which her notes indicated she confronted him with it at that point. Now, her testimony was that she believed, and I believe this in finding of fact 80 sets forth her testimony, not that this was accurate. But her testimony was, well, her position, he explained that all away, so therefore I didn't think it was exculpatory. And what the hearing committee did right after it pointed that out is it cited to Zanders. Zanders, which 2 members of this court sat on, or this panel sat on, was decided 2 months before she made these decisions. She was the trial lawyer in the case. She was on the appellate brief in the case. And this court told her, you, the prosecutor, don't make those decisions. If it's something that the defense might be able to use and it's as exculpatory information, you don't decide. The witness can explain it away, and therefore I don't have to disclose it. Now, the board, for reasons that, which I think is because they misread the hearing committee's findings, turn that aside and say, well, it's not conclusive, that it's not clear and convincing evidence that she didn't really believe it wasn't exculpatory or that she recognized it was exculpatory. That's not what the hearing committee found. I don't really want to grapple with the ultimate fact issue. I think I was in front of Judge McLeese one time, and he said that made his head hurt. But I would refer the court to its opinion in Crane, in which you said if the ultimate fact is entangled with the findings of fact, then the board is not free just to, make the ultimate, say, well, the ultimate fact wasn't proven without dealing with the findings of fact. And the findings of fact here, I think, are that Ms. Haynes was not credible in light of Zanders when she testified that she did not believe that she had to turn this information over.
That gets
Now,
us to exculpatory, right?
I'm-
If following along your argument, the hearing committee found that this was exculpatory.
Right.
how do we get, what does that have to do with the sanction if there's no finding of materiality? Are we free to make that determination one way or the other as to whether this was exculpatory and material, and therefore, whether it was pre-Klein or not, a sanction is still warranted?
I think those are two different concepts. If it was exculpatory, is one thing. Whether it was material because it was exculpatory is a second issue. It seems to me to go to the materiality that neither the board nor the hearing committee had the slightest difficulty with that issue. If you look at the closing argument of the defense in this case, the closing argument is this case rises and falls on the testimony of Mr. Morales. Mr. Morales is the central figure from the defense's point of view, the lawyers who were right there in the courtroom deciding the case. And there is this one fact, and they tried to go after him on, well, you came forward, 3 years later and so forth. This one fact, and when they testified, the defense lawyers testified, they said if they had known it, they surely would have used it. This one fact that undermined the entire presentation of Morales as the guy who didn't know how to come forward before, and that was never disclosed. Just to give you one example, go look at the Zaldivar letter. The first page of the Zaldivar letter, Mr. Zaldivar, writing on behalf of Mr. Morales, says, look, this is a bad guy. I'm paraphrasing, obviously. But what he says is that he's a lifelong gang member, career criminal. He founded this violent gang out in California. And then, flashing red light, but he debriefed to law enforcement. What they're doing there is selling his bona fides. So the fact that he debriefed to law enforcement, undermines him as a gang member. But then he gets on the stand and says, I'm a lifelong gang member, and only because these events occurred in my life just recently have I changed.
He didn't first say that on the stand. That's on pages 2 and 3 of the letter, though.
Yeah, that's right. You're right.
Whoever wrote that letter, Zaldivar, evidently didn't see an inconsistency between writing on page 1 that he had debriefed the government in the past, many years ago, and then saying on page 2 and 3 he's had a change of
right.
character.
He was.
I can well believe that somebody who debriefed the government, I mean, he put his life in their hands, you could say. Somebody who debriefed the government years ago might well continue to take the position. This is something I do not do. I do not, especially when I'm in jail, I do not, rat on other people. And, issues of self-preservation and a lot of other things would support that view. They didn't seem to, whoever wrote that letter, Mr. Zaldivar, and presumably Morales, who knew it was being sent, didn't see any glaring inconsistency in that. It's odd, isn't it?
I think there is. I mean, I think there's a difference between, as you just pointed out a moment ago, somebody who's incarcerated said, I'm not coming forward to testify. I don't want to put my life on the line. And then explaining that he's had a change of heart about that, as opposed to somebody saying that I don't know how to even come forward. I've never done anything.
I don't know how is a little excessive.
Say what?
Right. The I don't know how is a little bit.
Yeah, and he testified at the trial.
Yeah.
That's what he testified. And these lawyers sat through it. I do not want to, I've got 15 seconds left and I haven't really addressed Mr. Campamore at all. And the important thing that I think here is the issue of, I was going to go through all 3 elements, but let me just focus on intentionality. What I would say, a fair reading of what the hearing committee and the board said is that because Ms. Haynes submitted the final version of the Giglio-Brady disclosures, that Mr. Campamore did not intentionally not disclose them, that it was her responsibility. And the rule doesn't turn on the division of labor at trial or which lawyer on the team took responsibility. The rule turns on the knowledge of the lawyer who knows, the prosecutor who knows this information. Mr. Campomore wrote 2 drafts of the Brady disclosure. One he was dated September 20th, and he gave it to Ms. Haynes on the 21st, and one he wrote on the 22nd. After he wrote the second one, Ms. Haynes said, "I will finalize this." And she did on the 20th, and hers is dated the 22nd. She didn't disclose it for a few weeks later because there was a slippage in the trial date, but dated on the 22nd. There is no material difference between what Mr. Campomore said that Ms. Haynes ought to disclose and what she did disclose. She did 2 things. She took, his was written in more of a narrative form, and she converted it into more of a bullet point form. And she added a statement, which isn't a disclosure, saying that no promises have been made to Mr. Morales. So there was no change. And this is no different than a lawyer drafting a pleading that contains material misinformation or is frivolous on its face, and then that pleading being finalized by another lawyer. Both are responsible. And it means you don't have to do this little dance that we've done through the briefs, myself included, as to who had responsibility for this witness at the time. He knew it, and he didn't disclose it. And Ms. Haynes adopted his recommendations. And I would just refer to you to Rule 5.2. Rule 5.2 doesn't apply 100% here, but I think it makes the point that there are no Nuremberg defenses for lawyers who violate the standards of professional conduct. It says, for example, a subordinate lawyer is not exempt because he's acting at someone else's direction. So, for example,
May I ask, I take the point you're making about subordinate lawyers, but we have here, so what we have then is 2 rather experienced lawyers. Campomore is no naive young lawyer. He's been practicing for 6 years. He's done homicide trials. So we have 2 experienced lawyers, both of whom did not disclose this fact when they had the opportunity to do so. What explains that? I mean, Ms. Fink points out all the lengths to which the prosecutors went to turn over all sorts of exculpatory information, all sorts of information that would impeach their witnesses. And there's just this one instance in which they apparently don't do it. If we posit that they actually knew it was exculpatory, as opposed to should have known, actually knew, what explains that failure in this case? It's a little hard to understand, right?
yes and no. I mean, making a deluge of disclosures of a lot of information, some of which, may not be very useful or not, is, as I think I said, the briefs, disguising the needle in the haystack. You're turning over the haystack, but not the needle. But I would separate them out. With Mr. Campomore, I'm not sure the evidence is strong enough to say that he actually knew, understood that it was exculpatory, although he was present.
But let me add one thing to my question. They also know, and they think that they're going to disclose it eventually as Jenks material. Now, there's some sort of screw up there, and it doesn't get disclosed apparently. But it's not like they're not really thinking, or at least on its face, it's not like they're really thinking that this will never come to light.
Well, I'm not prepared to agree that that the failure to disclose his Jenks material was accidental. I mean, it should have been included in the Jenks package on 2 grounds. One, Mr. Kavanaugh testified, actually he testified to both of these points. Third member of the trial team. He testified that it was the practice of the U.S. Attorney's Office to turn over exhibits when it turned over the grand jury testimony, and they didn't turn over the exhibits with respect to Mr. Morales.
What was Mr. Kavanaugh's role?
Say what?
What was his role exactly?
He
I've been
actually
trying
kept-
to figure out who did what here, and this is an area that's a black hole for me. I don't.
Mr. Kavanaugh himself testified that he was a glorified paralegal. What happened was there was tension between Mr. Campbell and Ms. Haynes, and they assigned somebody else to sort of work with them at the last moment. But Mr. Kavanaugh had little involvement. I think he wasn't in the courtroom every day, for example. And so that was his role. And that
Was it he who put together the Jenks package?
No, this is another reason why I suggest to you that you need to focus on the knowledge and not whose role it was. Because the testimony was, nobody knows who put together the Jenks package. It's clear that Mr. Kavanaugh did not, I think, because he was really not playing that kind of a role. But Ms. Haynes testified she wasn't sure who put it together. Mr. Campbell said she didn't know who put it together, but it wasn't him. So, we don't know.
Let's get back to my question of what motivated these people to withhold that? If it's
Well,
really hard to.
I mean, I don't know what the motive was for Ms. Haynes, but I do know, for the reasons that you discussed earlier, that she knew this was, and the hearing committee found that she knew this was exculpatory, because she, as we said before, she prepared for it. And what I think the logical conclusion is that you could make an argument that only the second and third pages of the Zanzibar letter contained Morales' statement.
Right.
And remember, 18 U.S.C. 3500, the Jenks Act, as we call it here, says you have to turn over the statement of the witness. And the way the letter is structured, the first page is kind of introductory, and the second page purports to paraphrase what Morales said. So somebody could make a conscious decision not to turn over that first page as Jenks material, and therefore conclude that I don't have to pull the sting, that I don't have to confront him or bring out at trial the fact that he debriefed before, because we're not disclosing that. Now I can't read people's minds, but that's all I can
Well,
offer on that regard.
Could we argue that could be a mistake? Hey, we just need to provide the jinx, or I won't call it jinx. We just need to provide Mr. Morales' actual statement, which does begin on page 2 and is on page 2 and 3 of the letter.
Right.
And so this first page is just superfluous.
Right.
And none of the prosecutors at the time or since have said that they saw that notation of a debrief without any further details as exculpatory.
Well, they certainly haven't admitted that. I agree with that. They haven't said that. But what I'm saying is that actions speak louder than words here. And that when you have Ms. Haynes first trying to prepare the witness to deal with it, that's evidence that she knew it was exculpatory. And particularly her rationale, which the hearing committee rejected, that she could make a determination on her own that he had a good explanation for it, and therefore she didn't have to turn it over as Brady and Giglio material. In light of the Zanders case, came, addressed to her 2 months before, that just doesn't hold up. It's not credible.
Well, what do we make of this hiding in plain sight point?
I'm sorry, I could not hear you.
What do we make of this hiding in plain sight point? That the disclosures clearly had, this is page 2, this is page 3. We all know this is an incredibly important witness. Anybody could have gone and asked for page 1 and would have had to gone through a process and whatnot. But doesn't that look like it, to your opposing counsel's point? If I was trying to hide it, I would have at least whited out those page numbers or something, right?
Well, I guess I'll say 2 things about that. The defense lawyers testified that they thought that the only, just consistent with what I was just saying here a moment ago, that the only portion of the letter that was Jenks material was the second and third pages. And there was at least one other instance, which we brought out and is in the record, and I can't remember right now, where in turning over Jenks material, the prosecutors turned over less than a complete document because they said the Jenks material was located on, it wasn't pages 2 and 3, but in this instance, and so that's why we're not turning over page 1. So it's not, it was not inconsistent. So
Well, my recollection is that at trial, the defense raised the question of where's page 1? We didn't get it.
yeah, what happened was at trial, the prosecutors wanted to offer as a prior consistent statement. I don't think it really was the entire letter. And the defense objected to that and said, we've never even seen page 1. Spontaneous remark made when the prosecutors offered that evidence, they tried to offer the entire letter into evidence. And then later they withdrew the proffer of evidence, didn't try to move it in. And so that issue.
So even when they proffered it, they didn't actually show it to the other side?
There's nothing that said they did.
Now, the fact that they were proffering.
And I know they didn't because, I'm sorry, I interrupted you, I apologize, because the defense counsel testified they didn't. And they were found to be credible by the hearing committee.
Oh, wait, well, maybe I misunderstood you. I mean, what occurred to me as you were saying it, but maybe I misunderstood, is that the prosecutors were prepared to offer at trial the entire letter. That does suggest that they didn't understand that the letter contained, the page 1 contained exculpatory information which they had not turned over, doesn't it?
May or may not, because they withdrew it. I mean, they tried.
When there was an opposition.
Well, the opposition, when they said, we haven't even seen page 1, and then nobody says, here's page 1, and then the government withdrew the offer of evidence.
But at a minimum, you would think it demonstrates a kind of sloppy job of trying to hide something.
Yeah, if you accept the premise that they had an obligation to turn over the entire letter as Jenks material. And again, I'm trying to distinguish between Jenks and Brady here.
Yep, particularly.
And what we're focusing on here is the Jenks material. But, it is the case that sometimes the obligation is only to produce the statement of the witness under 18 U.S.C. 3500, the prior statement of the witness. And the first page wasn't a prior statement of the witness, so that's a defensible argument.
I see that, but what troubles me a little bit is, I mean, you have a situation, if I understand correctly, where these prosecutors think that they are going to be showing this letter in its entirety to the defense and indeed using it at trial. They're prepared to do that. Now, they ultimately don't do it. They're stymied, they're whatever, but they're thinking when they walk into that courtroom that they're going to, try to do it.
Ooh,
Now, that does suggest to me that, but they didn't turn it over at the Giglio turnover date. Now that suggests to me that they didn't realize, they honestly didn't realize that it was Giglio.
well, that's one, I agree you could draw that conclusion. It's not the conclusion the hearing committee.
No,
drew, but,
I've got that.
Yes, but also, if we talk about sloppiness, spontaneously and somewhat spontaneously, because this was not something that was planned at the whole thing. It came up in the middle of the trial. As okay, they cross-examined Morales, so we'll offer it as a prior consistent statement.
I'll just say, if I was a nefarious guy and I had deliberately withheld the smoking gun, I wouldn't be so sloppy as to say in the middle of trial, oh, well, let me use that as evidence.
Yeah, I agree with you, but if you did,
I like to think I would not.
but if you or this hypothetical person did come up with the idea spontaneously, try to use it as evidence, they might say, oh, wait a minute, we don't want to turn that over, and they withdrew it. I want to say one word about sanction, and then I know I've abused my time. The reason I believe that the knowledge is the triggering event is that the consequence of failing to, of a prosecutor's failing to disclose exculpatory evidence is so potentially serious that the potential harm that can be done, putting something, you know, Judge Deal made this point in his dissent in Dobie, that, you know, we sanction serious sanctions on the lawyers for misappropriating clients' money. But taking somebody's life, I don't mean killing them, but I mean taking away their freedom is a much more serious consequence. And we have in this we cited to you a host of situations where that's occurred because prosecutors have not made the disclosures they were required to make. And one of those cases is right here in this jurisdiction. It's in our brief. Donald Gates, 27 years in prison, exonerated by DNA, in prison for first-degree murder and rape, exonerated for DNA, and the government did not make disclosures. A serious sanction has to be imposed. And we have suggested that a 6-month suspension ought to be the minimum. But it has to be a serious sanction. You haven't done it in Klein, you didn't do it in Dobie and Taylor. At some point, I think the court needs to impose a serious sanction on a prosecutor so that this kind of conduct will not occur in the future.
Do you agree that the level of the sanction, that it does make a difference, a material difference to the sanction? Whether the prosecutors in fact knew that the withheld evidence was exculpatory or merely should have known?
As you phrase the question, the answer is yes, I agree. But the caveat that I would make is that that doesn't mean that the prosecutor who should have known and didn't make the disclosure should not receive a sanction, and it's sanctioned to be a suspension. That's that's the point that I want to make, because the deterrence is very important here. As you pointed out in one of your opinions, it's, you know, when a violation is difficult to find, that's another reason for deterrence. And, you know, it's very difficult to prove what you don't know. So we would urge you that a suspension sanction is necessary for both of these lawyers.
Let me ask you one more question along those lines of the sanction. You know, a lot of these other cases were nowhere near as high profile. These attorneys have taken a pretty good beating in the media and elsewhere as it's been put out to us. How much of an appropriate consideration in your view is that for us?
I really don't think it is, because as this court has said many times, the purpose of sanction is not to punish the lawyers. I mean, I heard a moment ago that Ms. Haynes has had all these consequences, and I'm sorry about that, but that's not the purpose. The purpose is to, among other things, but I would say the primary purpose is deterrence. And prosecutors need to be deterred from Brady violations. They're hard to discover. They have serious consequences for defendants. And when they are discovered, a serious sanction needs to be imposed.
Well, the board found that there wasn't actual knowledge, but that Ms. Haynes or a reasonable prosecutor should have known that the material was exculpatory, and recommends a less serious sanction, but a suspension nonetheless. I guess, where do you part ways? I know you mentioned earlier that the board, you think, may have misunderstood one of the hearing or some of the hearing committee's findings. Can you elaborate on that?
Well, the board took finding of fact 80, which I read to be the hearing committee setting forth what Ms. Haynes contended what was the law about whether she should have to make disclosures, okay? But there are 3 findings of fact in a row: 79, 80, and 81. 79 sets forth Mr. Campamore's view of his obligations. 80 sets forth Ms. Haynes's, and I suggest to you that what the hearing committee is doing is saying this is what they testified to, because 81 then goes to Sanders, and it says 2 months before the court told Ms. Haynes that she could not use that rationale. She couldn't use the rationale that the witness cleared this all up, so therefore I don't have to disclose it, because the court told him you couldn't do that in Xander's. And then later in the discussion, I think it's on page 40 of the hearing committee report, the hearing committee discusses Ms. Haynes's explanation as a rationalization. And so I take all that to mean that they did not believe her. They set forth what she said. They didn't believe her because she couldn't believe that because of Xander's, or at a minimum, she was being willfully ignorant, which is intent in our jurisprudence.
All right.
Thank you.
you.
Any more questions?
All right, thank you, Mr. Fox.
Good morning, Your Honors, and may it please the court. Daniel Randolph on behalf of Mr. Campamor Sanchez. There is a lot to respond to here today. I say that despite the fact that many of the arguments that have been raised thus far, this court does not even need to reach for Mr. Campamor Sanchez. Our primary argument before this court is that it should affirm the rulings of the hearing committee and the board using the rationale that the hearing committee and the board found to dismiss all charges against Mr. Campamor Sanchez. So I want to focus primarily on some of the factual and legal mischaracterizations that were just raised and that address those particular grounds. First of all, as to what Mr. Campamor Sanchez actually turned over to Ms. Haynes and what was his role in this disclosure process. Disciplinary counsel used the term recommendation. He has used that phrase in briefing. He attempted to elicit that from Mr. Campamor below before the hearing committee. Mr. Campamor never made any recommendation as to what should go in that final disclosure. He prepared 2 rough drafts. These rough drafts had question marks. They had brackets. They had placeholders. They were clearly incomplete. And I think critically, when Mr. Campamor turned over his first draft to Ms. Haynes, he said, he included in his cover email a very simple sentence. It was, "Here is what I have so far, ... So this was, disciplinary counsel attempted to compare this to a pleading that an attorney, the first draft of a pleading that an attorney sends to someone to file in court. It wasn't close to that level of finality. Disciplinary counsel also said,
point when Mr. Campamor knew what was being, what the final letter looked like.
Your Honor, the hearing committee and the board found that he had no knowledge of the letter when it was disclosed, and in fact did not have knowledge of the contents of that letter until more than a year after the trial concluded. And that was one of the key factual findings that the hearing committee and the board relied on in concluding that Mr. Campamor did not intentionally fail to disclose this information. The other 2 factual findings were that as of the time of the disclosure, he had no responsibility for Morales as a witness. Ms. Haynes had completely assumed responsibility for Morales as a witness at the time. Disciplinary counsel in the briefing attempted to muddy the waters on that issue. It sounded to me like he was not disputing that fact before this court
Can you
today.
remind me of whether the hearing committee made a specific finding that Mr. Campamor Sanchez did not think or believe or know that he was aware that the debrief information was on page 1 of the letter. Did the hearing committee make any findings about whether he knew it was exculpatory or that a reasonable prosecutor would have known that should have known that it was exculpatory?
So Mr. Campamor's testimony on this was that he did not think, that was his word, he did not think that if he had actually had the opportunity to review that disclosure, revise that disclosure, have any sort of participation in the finalization of that disclosure, he did not think he would have included the statement. But he also said that
Did they
he had
ask
no-
him specifically if he thought it was exculpatory, or
Right,
Yes.
his subjective view was that it was not potentially exculpatory. He didn't see an issue. And just to circle back, we were discussing earlier the fact that the letter was introduced before the grand jury. And that was Mr. Campamore. He introduced the full letter before the grand jury. There was an argument to the effect that there were no questions about page 1 before the grand jury. That's incorrect. So I would direct the court to page 92 of the grand jury transcript, where Mr. Campamore does ask a question about content that is only on page 1. I think it's just the addressing information, but the point is he wasn't trying to hide anything. You know, this letter was clearly marked at the header at the top with the page numbers. There was an exhibit sticker that was only on page 1, and Mr. Campamore referred to that exhibit sticker. So
Should a reasonable attorney in Mr. Campamore's, reasonable prosecutor in Mr. Campamore's position have known that page 1 contained Giglio material?
our view is no, Your Honor. Our view is also this court does not need to reach that question for Mr. Campamore. And the reason why this court does not need to reach that question for Mr. Campamore is that at the time of the relevant disclosure, he was not responsible for that disclosure. He was reasonably relying on Ms. Haynes's representation that she would handle that disclosure. And that relates back to one other aspect of the record that
What
I
was he
didn't
doing
want
in
to
giving her a
correct.
draft?
Apologies, Your
I
Honor.
mean, he's giving her a draft. Yeah, the purpose of the draft is presumably to say, here's what I think you should disclose, have to disclose.
Well, Your Honor, I think that's
And he left
inconsistent.
that out.
Well, Your Honor, I think that is inconsistent with the record. I think what he had was what he had prepared so far. It was a snapshot in time. It was not a recommendation as to what should go over to defense counsel. His email, this is the email dated September 21st at 6:37 p.m. He says, here is what I have so far, ... And then the very next day, he sends one more email to Ms. Haynes, and he says, this is the last thing I did last night. And there's a couple other mentions of things he added to the letter, but there's never any point where he says, you know, from my perspective, this is pretty much ready to go. Or here's what I recommend including, or the only other thing I would suggest adding here is X. There's no suggestion here that this was he never
His
represented.
drafts don't include any information from page 1 of the letter, or any referenced information from page 1 of the letter.
That's correct, Your Honor. It does not include, his drafts did not include the debrief statement.
As
And again,
a
I think,
member of the prosecution team who takes seriously his responsibilities under Brady, is he not at fault for failing to bring this up?
under the circumstances, our view is no, he did not. And again, I just want to point the court to factual, we're on a substantial evidence review standard here. And so all these factual findings deserve deference from this court. Factual finding 33 of the hearing committee expressly finds that Mr. Campamore did not have the opportunity, that's the words of the hearing committee. He did not have the opportunity to review this letter, to edit this letter, to participate in the finalization of this letter. And I think what went into that factual finding was this very, unusual trial dynamic between Ms. Haynes and Mr. Campamore. She was clearly the lead prosecutor here. Virtually every witness before the hearing committee testified to the fact that she was the lead prosecutor. She was making the final decisions as to the allocation of responsibility. And her email to Mr. Campamore is an unambiguous direction that she is going to handle this. And this is the other piece of this that I wanted to correct the record on. Disciplinary counsel said that she simply said that she would finalize it. That's not what she said. She said to Mr. Campamore, I need to revise it. I need to revise it. And then she said, just want to apologize. I want to make sure I have the exact sentence here. I'll take care of getting out the Giglio letter. So she made a very clear representation that she was going to handle this, and she was the lead trial counsel. In fact, she had made decisions before that Mr. Campamore had disagreed with. He was consistently attempting to take on more responsibility. He had wanted to handle Morales at trial. He had wanted to cross-examine Guandique. he had wanted to do the closing argument. And in each of those instances, Ms. Haynes said no. And her word was final, and that's what happened. You know, he did have some experience. Mr. Campamore had some trial experience by that
Well,
point.
notwithstanding the, not to cut you off, I'm sorry, counsel.
Oh, I'm sorry.
But notwithstanding everything you just said about his role as the junior prosecutor on a team, does any of that relieve him of independent obligations under Rule 3.8, Giglio and Brady?
Yes, Your Honor. We're certainly not saying that just because he was the junior prosecutor, you know, he's off the hook. We're not advocating for a broad rule here at all. Our position is that under the facts of this case and based on the factual findings that the hearing committee made and that the board adopted with respect to Mr. Campamore, he did not intentionally fail to disclose the relevant information. And the reason why is because he reasonably relied on the direction from Ms. Haynes that she would handle the disclosure. And so, and our view is that.
And I guess as a part of that, I guess that answer doesn't completely satisfy my question. What you said earlier about factual finding, I think you said 32 from the hearing committee.
33, Your Honor.
33 specifically found that he did not have a reasonable belief, or he did not know or think at the time that this was exculpatory.
So finding 33 determines that Ms. Haynes was solely responsible for the disclosure and that he did not have an opportunity to review the disclosure or otherwise make revisions to the disclosure before it was sent out to the defense. So that was the factual finding I was pointing to earlier. I think just to go back to Your Honor's question about the breadth of the rule here, I mean, I think it would be relatively easy to envision other scenarios where this would come out differently. We're not saying that anytime there's a division of trial responsibility on a prosecutor team, you know, one prosecutor is off the hook. We're saying that here there was reasonable reliance on the division of labor, and it would be unreasonable in other cases. So for example, if Mr. Campamore was the only one with access to the Zaldivar, the key statement here, the debrief statement on page 1 of the Zaldivar letter, that would be a very different case, because it would not have been reasonable for Mr. Campamore to accept Ms. Haynes' direction that she was going to handle the disclosures under those circumstances. We would also concede this would be a different case if Mr. Campamore was the lead trial counsel and he was attempting to sort of delegate responsibility to someone else, because that could potentially suggest an attempt to evade responsibility under the rules. But this was the opposite situation. He was on the receiving end of a direction from Ms. Haynes that she was going to handle this disclosure, and it was in the context of a trial dynamic where, you know, what Ms. Haynes said was final. Just on the legal point, disciplinary counsel's position here is, in our view, impossible to reconcile with the actual text of 3.8E. I just wrote down some notes earlier about what disciplinary counsel represented to this court, and I think they're consistent with what's in his briefing. I heard that disciplinary counsel's view is that the rule does not turn on the division of labor at trial, that it, quote, turns on knowledge, and that, quote, knowledge is the triggering event. Well, the problem with that position is that it completely writes intentionality out of the rule. This court's opinion in Dobie-Taylor made clear that there are two mental states in 3.8E, not just one. And so if that's the case, the word intentionally has to be doing some work here. It can't be sufficient to trigger liability simply for a prosecutor to have knowledge of relevant exculpatory information. And that, of course, makes sense, because there would be all sorts of radical consequences if the court were to accept that rule. You could have a situation where a prosecutor was risking his bar license because he was copied on an email with exculpatory information, even though there was one prosecutor that clearly was, under the circumstances, responsible for making the relevant disclosure. And so in our view, disciplinary counsel is not reading Dobie-Taylor correctly. The relevant standard is purposefulness. And this court defined intentionality in Dobie-Taylor as requiring an element of purposefulness, deliberateness, or aggravated neglect. And that is the standard. It pointed to the possibility of an accident as an example, just one example of where that intentionality requirement would not be satisfied, but it's an example. And our position is that this is a perfect illustration of another way in which that intentionality requirement cannot be satisfied. Mr. Campamore reasonably relied on Ms. Haynes's direction here. And so for that reason, this court should affirm.
Well, you know, a lot depends on what you mean by these words. You know, recklessness or negligence, I think under our case law would also suffice, even in the absence of purposefulness. Do you disagree?
I disagree that negligence would suffice, Your Honor. This
Yeah, I
court,
think we've spoken in an elevated degree, about an elevated degree of negligence, although I'm not sure, but go ahead.
yes, Your Honor. So again, both in Klein and in Dobie Taylor, this court was clear that intentionality requires an element of purposefulness, deliberateness, and aggravated neglect. So I think it's clear just based on how the court defined it that it's more than
So
negligence.
as a hypothetical, suppose Mr. Campo and Moore did know that the disclosure was omitting the information about Morales's debriefing, past debriefings. And suppose he did know or did appreciate that such information was Giglio evidence. But it wasn't his responsibility to do it. He had just given a, you know, preliminary draft to Ms. Haynes, the senior attorney. It's okay for him to just stand by and say, well, Ms. Haynes is doing that. It's her problem, not mine.
No, Your Honor, we would concede that that is a different case. And that is why one of the key factual findings that the hearing committee made and that the board adopted below and that we're relying on is that Mr. Campamore did not have knowledge of that letter. If he had knowledge of that letter at the time it was turned over and saw that the debrief statement was missing, at that point, we would concede that there would have been an obligation to supplement or follow up at some point. I also do want to just point out.
Suppose he knew that the letter was being prepared by Ms. Haynes, and he knew from his own personal experience with the case that there was certain Giglio information that needed to be disclosed. Is it okay if he knew that but didn't bother to check that the letter contained that information?
Your Honor, we would also concede.
In other words,
Right.
of responsibilities go that far?
Right. I think in that case, it would also be distinguishable because in that case, Mr. Campamore would have, if I understand the hypothetical, he would have information that only he had and that Ms. Haynes did not have. And I think in that situation, we would also recognize that there is an obligation for him to make sure Ms. Haynes included that information in the disclosure. But again, this case is different because there's a factual finding in the record that Ms. Haynes and Mr. Campamore both received the full Zaldivar letter in March 2009, and they both reviewed it soon after they received it. Ms. Haynes had access to that grand jury transcript. So there's no dispute here that Ms. Haynes had full access to the relevant information that has given rise to this case.
What is your answer to the question that I either explicitly or implicitly asked earlier, namely, why didn't these people realize that this was Giglio information?
Well, you're right.
Given the nature of the explanation that they were presenting at trial, that what's been characterized as the sinner to saint transformation of Mr. Morales, for shorthand. Why is it that they both, you know, if it's true, didn't know that this was Giglio?
Well, Your Honor, I think the answer is that hindsight bias is playing a really significant role in this case. You know, the relevant disclosure is one fragment of one sentence on one page of one letter. And yet we now know we have the benefit of a multi-year post-trial investigation by a team of DOJ attorneys that left no stone unturned. And so I think that all of that is influencing how, you know, 15 years later, we're all looking back at this and thinking, well, what shouldn't have been so obvious. But I think picking up on your Honor's earlier point, it's not obvious. If you just limit yourself to looking at that first page of the letter, it simply says that he had a prior debrief with law enforcement about his own gang involvement. So the statement not only it mentions a prior debrief, but then
Not actually, you threw in a few words there that are not, but all right, go ahead.
well, I didn't mean to, and so why don't I'll just pull up the exact text of the letters. So just so I'm careful not to misstate anything. So the statement is that Morales is also a dropout. He debriefed to law enforcement about his gang involvement and is no longer considered an active member. So the critical phrase, I think, is about his gang involvement. I mean, the statement doesn't just say he had a prior debrief. It includes further information saying this is what the debrief was about, his gang involvement. And so I don't think there's anything inconsistent about that statement and his later testimony that, you know, he had never told on others. He would never snitch on others. He would never incriminate others. You know, again, our primary argument on appeal doesn't rely on this court. This court doesn't even have to reach this issue for Mr. Campamore. But to answer your Honor's question about why both prosecutors didn't turn this over here, I think the answer is it just wasn't obvious. This wasn't, especially, I mean, the circumstances of the case are so important. This was a case with 20,000 pages of discovery, 40 witnesses, and yet there's only 2 prosecutors handling all of that. It was an enormous burden. You know, very senior prosecutors in the U.S. Attorney's Office testified before the hearing committee, including former principal U.S. Attorney Alessio Evangelista, who said, you know, this was a case with an extraordinary volume of discovery, 95 boxes worth of material. And here we are, this entire appeal arises based on a few words on one page in one letter. So I do think that that's extremely important context in understanding what animated the conduct in this case.
Well, I mean, I think that minimizes the importance of the letter. I mean, everyone recognized that the letter was important. You know, even though what apparently was turned over was page 2 and 3 of Morales' statement, Morales is central. He's key. Both the government and defense counsel rely on references to his testimony, characterizations of his testimony in their closing arguments. So I don't think this was a needle in a haystack kind of situation. I think this was a piece of evidence that or material that everybody viewed as significant. And, you know, whether this one line on the first page jumped out, I think the character, this is more than a de minimis document taken as a whole.
Well, Your Honor, I won't dispute that Mr. Morales played a meaningful role at trial. I do think it's important to emphasize, and I won't dispute that the letter was important. I mean, pages 2 and 3 in particular included the first account of the relevant confession, and so that was obviously important. You know, I think that it is important to keep in mind, though, that there was an active grand jury investigation underway at the time the Zaldivar letter was received. Mr. Guandique had already been arrested on probable cause. There were lots of other confession witnesses that were available. The prosecution only ended up calling one at trial. But, you know, again, this is a way in which we're seeing this through a different lens now than it was seen at the time, because Mr. Morales was one of a number of witnesses. And I think as it played out, Mr. Morales turned out to be the one that was called. But at the time, whenever the prosecutors were making these disclosures, there were actually a lot of confession witnesses. And that's not even to mention, you know, the other there were 40 witnesses altogether. So you know, there were witnesses that, you know, from, you know, Mr. Guandique's girlfriend and landlady there was testimony about his statements that were incriminating as to why he had certain injuries. And then there was a lot of modus operandi evidence as well from victims who had been attacked by Mr. Guandique in Rock Creek Park, including one that barely escaped the day of the relevant incident. So there was a lot of other compelling evidence, and I'm not attempting to minimize here. I think we would concede that whether this was potentially exculpatory information is at least a thorny issue, and that's why our primary grounds for appeal here, for affirming here, are the grounds that are set out in the hearing committee's decision and the board's decision. I see that my time has expired, Your Honors. Unless there are any further questions, we would ask that the court affirm the dismissal of all charges against Mr. Campamore.
All right, thank you.
Thank you.
Forgetting what order we're going in again. Ms. Fink, all right.
I'm being invited on. I just want to make one point. As I heard the argument, the case turns on the fact of, from my friend's point of view, as to whether Mr. Campamore read the Giglio letter. I mean, he drafted two versions of it. There were no incidentally question marks or incomplete portions with respect to what he said about Morales, and there are no substantive changes to it. There were other things that need to be filled in, no question about it. But as I think I heard him say, if he had actually read it after it was sent, this would be a different case. So what that means is that a lawyer can draft a letter that leaves out important exculpatory information, but is off the hook if somebody finalizes it and he doesn't read it. And that makes no sense to me. It seems to me this is, I agree with him that there has to be knowledge that which triggers the responsibility, and then he intentionally has to not disclose it. But when he drafts something and doesn't disclose it, and the person who finalizes it accepts, he doesn't say it's a recommendation, I think a draft is a recommendation, then he ought to be responsible for it. If Ms. Haynes had told him, don't put in the debriefing under Rule 5.2A, that would not have got him out of this problem if that debriefing had to be disclosed. So even then, he would have been responsible. And here, she didn't tell him not to put it in. He made that decision on his own. He knew about it. And he intentionally did not disclose it. And Ms. Haynes adopted his draft, or the substance of his draft. I would submit that he is equally responsible.
Thank you. Ms. Fink?
I'd like to draw the court back to the existing framework in Dobby Taylor. I think, we've talked enough today about the first question about whether Ms. Haynes actually thought that it was exculpatory. I'd just like to make a couple points on the reasonableness. It's telling that ODC has never been able to point to a single prosecutor who thought that this was exculpatory. There are many, many prosecutors who thought just the opposite. So for this court to write an opinion finding that she should have known, that opinion would have to say that despite what all of the other prosecutors have said. And that is distinct from Klein, again, where in Klein, every prosecutor who looked at the information afterwards thought it was exculpatory. And that's also different from Dobby Taylor, where Dobby and Taylor and all of the prosecutors who looked at it afterwards thought that it was exculpatory. It's also telling that ODC has never, and still today, we've been doing this case for over 4 years. He still has not been able to come up with a motive for why they would do this. The simple answer is that they didn't. They didn't view it as exculpatory. It was a reasonable opinion at the time, and you should find that Ms. Haynes did not violate Rule 3.80.
Then how do you counter the board's position that a reasonable prosecutor under these circumstances should have known?
The board misreads Zanders when it makes that determination. The board looks to Zanders and says, well, based on this ruling, essentially anything that the defense wants to know, could be interested in, should be disclosed. But Zanders says that it's only things that are on their face exculpatory. And I think it's important for the court to look at the context of other cases, in this court that have found to be that sort of exculpatory information. And then compare that to the mention of a debrief and sort of, see where that comes out. So for example, evidence of a potential third-party perpetrator, an eyewitness who said they couldn't remember what happened, a government witness who had entered into a plea agreement as part of that testimony, and a payment to a witness. So those are, in one bucket of information, where I think the debrief, at a minimum, we can say it was a question. It was not screamingly obvious. And for those reasons.
Well, I mean, if you were a defense attorney and Mr. Morales is on the stand and he repeats what he said earlier, which is, I wouldn't even know how to go forward and to come forward. That's why I needed Mr. Sandoval's help. This was a complete change in my personality that resulted in my coming forward. I never would have done this. And you're saying to yourself, well, geez, it's not looking good for my client. I really need to undercut that testimony in some way. It wouldn't be obvious to you that if he, as a defense attorney, that you'd want that information, that he had actually a history of debriefing the prosecutors about serious criminal activity?
Yeah, and I will point out to the court, I am a defense attorney, and so this is a bit of a reversal of roles where I still am a defense attorney. It just happens to be that the respondent is a prosecutor. But in that situation, I guess, one, I would say, well, let's look at what the standards were for what needed to be disclosed, not what would defense like. There's plenty of things I would
No, I
like to
agree
have.
with that. When I was a defense attorney, I wanted everything.
Of course, of course. And then even if we look though, so going back to what they knew at the time, 15 years ago, if he had been asked about it, most likely what would have happened is he would have said exactly what he told Ms. Haynes. Yes, I talked to law enforcement about myself. Oh, but you just said you don't know how to come forward. Well, I didn't come forward. They came to me. And without the investigation that took, close to 2 years afterwards, that's all it is. So comparing that to the other types of information I just went over, it's a completely different kind. If there are no other questions, thank you.
All righty. The court, I guess, Mr. Randolph, I don't recall if you reserved any time for a rebuttal, but if you'd like a brief moment. All right, we'd like to thank all counsel for your briefs and arguments today, and the matter will be taken under advisement. All right, our third and final case today is Keith Dimitri Johnson versus United States.
Chief, I feel like we got a lot less popular all of a sudden.
No. Counsel, are you ready to proceed?
Yes, ma'am. Good morning, Your Honors, and may it please the court. William Collins on behalf of Keith Dimitri Johnson. I'd like to reserve 2 minutes of my time for rebuttal. This court should remand this case for reinstatement of Mr. Johnson's appellate rights for 2 reasons. First, the trial court's attempt to weigh the evidence in this case was fatally compromised by 3 distinct errors that we've laid out in our brief. And second, even taking Ms. King's testimony at face value, the record shows that she failed to appropriately advise Mr. Johnson regarding the advantages and disadvantages of taking an appeal. So I'd like to address both of these issues in turn. But first, as to the trial court's errors in weighing the evidence, the first 2 were of a piece. We think the trial court erred in reading Bangura versus United States, this court's opinion in that case, to prescribe a requirement for extrinsic corroboration that simply does not exist. And the second error, before I jump back into the first, and forgive me for skipping around, is that the trial court found the absence of written corroboration for Ms. King's testimony to be entirely irrelevant, based solely on the fact that Mr. Johnson bore the ultimate burden of proof. Now, the sort of myopic focus on corroboration for Mr. Johnson, the double standard here, the insistence that he produce letters or the testimony of his wife, that was legally erroneous.
So let me ask you then, because perhaps this is different than what I understood your argument to be when reading the briefs. Is it that there's a double standard and there shouldn't have been such a focus on corroboration across the board? Or are you saying there is an independent focus on corroboration that should have been applied to Ms. King, even in the absence of a focus on corroboration on Mr. Johnson?
This may not be a helpful answer, but I think I'm saying both. The first, so as to Mr. Johnson's testimony and the court's attempt to parse it and analyze it, we have in her application of Bangura, we have at the hearing itself, she says, what's the level of production that has to occur? And so that's what we're focused on, this notion that there is a level of production that has to occur separate and apart from his testimony in order to even authorize a writ of error quorum nobis, a finding in his favor. Bangura does not support that. And when we get to the first line of analysis in her opinion, she says, on the merits, she says, ultimately, Mr. Johnson failed to produce any evidence other than his own testimony in support of his claim. She goes on to say he did not meet the minimum evidentiary standard for a writ of error quorum nobis. And, you know, she concludes on this note, having the burden of proving the allegations in his petition, Mr. Johnson failed to produce sufficient evidence, her words, anything more than his own testimony corroborating that he requested Counsel King file a notice of appeal. And so that is the essence of our first claim of error. It's that she held Mr. Johnson to this burden of production, not merely proof by a preponderance of the evidence.
So is that the same as a heightened standard? Did she erroneously apply a clear and convincing standard when she should have been applying preponderance? When you talk about burden of production, are you making that equivalent to this notion of a heightened standard, burden of proof?
So she certainly concluded that a clear and convincing standard was appropriate.
But did she?
Sorry, but she then purported to apply a preponderance standard in weighing the evidence. But respectfully, the actual weighing seems entirely inconsistent with what a preponderance standard might look like. We cited a case to your honors from the Second Circuit, United States, ex rel. Brennan, a habeas case, both holding that the preponderance standard applies in the quorum nobis context, and sort of teasing out when you might find the kind of analysis that she engaged in, which is if the petitioner is testifying as to matters long ago, or his testimony is refuted by documentary evidence. And it's sort of not what you tend to see, not a standard that jibes well with the preponderance standard, given two equivalent pieces of testimony, from Mr. Johnson and then his trial lawyer. And Bangura, Bangura being very far off point, because in that case, you have the conclusory allegations of an affidavit, as opposed to a detailed and thorough accounting of the steps that led Mr. Johnson to both believe that his notice of appeal had been filed, and then to assert that Ms. King had violated his right to counsel by failing to do so.
And an opportunity for cross-examination, right?
And an opportunity for cross-examination, that's exactly right. And so for all of these reasons, there was an error just as to the consideration of Mr. Johnson's testimony and this insistence upon corroboration by the trial court, which I think dovetails with we submit erroneous finding that the clear and convincing standard applies, notwithstanding the lip service she paid to the preponderance test. The second error, the judge found that absence of written corroboration from Ms. King's testimony was sort of no moment, because Mr. Johnson bore the ultimate burden of persuasion in the case. And that we submit cannot be squared with this court's opinion in Lauren Johnson versus United States, the 1986 case, where this court said, you know, of course, waiver of an appeal by a decision not to file a notice of appeal should be guided by this decision, which held that a signed waiver was required in order to voluntarily dismiss an appeal that had been filed. The court goes on to say, counsel is expected to keep records of the nature and scope of the advice given to inform the waiver, even in that circumstance where no notice of appeal has been filed. Ms. King, you know, there's a certain disconnect between Mr. Johnson and the government insofar as the government has just set all of that aside. There's been some discussion of the letters, Mr. Johnson, the letters he alleged that he had written to counsel. Our claim as to this error isn't focused solely on those letters. There was cross-examination and impeachment of Ms. King regarding what steps she took to document these conversations that she allegedly had with Mr. Johnson, wherein he said, "I don't want you to file my notice of appeal," or words to that effect. You know, page 73 of the hearing transcript, how about any notes? Did you take any notes of your conversations? Well, of conversations, yes, sometimes when clients called. I can't find a note of the phone call where she says he made the purported waiver. And, you know, she's asked point blank, and did you make a note of this one? Did you bill for it? And she says, probably not, because it was just a follow-up call. That conception of her obligations with respect to record keeping is fundamentally at odds with what Lauren Johnson says counsel are expected to do. Under those circumstances, it's necessarily relevant. It doesn't have to carry the day, but it's necessarily relevant to the credibility that her testimony deserved. And the trial court's only consideration, pardon me, Your Honor.
You said your last statement about her actions don't seem to be consistent with the level of what a trial counsel should be doing at this time. But there was, I guess, at the hearing, she was able to demonstrate that where he had previously asked her to file appeals on his behalf, she did. And there doesn't seem to be as much evidence exhibited or put forward on the other side. And the burden here is on Mr. Johnson, right?
That is, Your Honor, the burden was on Mr. Johnson, and the fact that she had filed a notice of appeal in his separate felony assault case is some evidence in favor of the government's position that she would have done so here had he simply asked. And the trial court took that into account. I don't think any of that defeats the claim that we're making, that sort of an error was made in believing that, like, sure, her prior conduct may serve to bolster her credibility somewhat. The fact that she didn't make any notes of this purported waiver should undermine her credibility, because it's an important thing to make a note of. And you can't get past that simply by noting, as the trial court did, well, Mr. Johnson, it's your duty to come forward with you have the burden of persuasion in this case. She's a licensed attorney.
But by the purported waiver, what are we talking about? Her recollection of her discussion with him about you've already served your time here and what would be the point of an appeal?
That is the essence of what she said the waiver was. And that testimony, I think, doesn't do her as many favors as the trial court imagined, because it suggests that she thought, she's sort of superimposing her own judgment about the value of an appeal on top of Mr. Johnson's, even though it's supposed to be sort of his determination whether this made a difference.
But she does say that he agreed with her.
That is her testimony,
So
but
it
the
comes
court
down to his word against her word, or is more, and then a credibility determination needs to be made between the two?
a credibility determination needs to be made between the two.
And that was done here to some extent by the trial judge, right?
Well, Your Honor, I think her attempt to weigh the evidence and to come to that credibility determination that was required was compromised by her, as I've said, the misconception that Mr. Johnson, being the petitioner for the petition for writ of error quorum nobis, needed to come forward with some corroboration. He needed, if he referred to the letters, he needed to put them in front of the court. Or he needed to bring his wife or an affidavit from his wife. And in addition, this notion that Ms. King bore no responsibility for corroborating her testimony, her lack of corroboration essentially could not
Did she
undermine her
have
credibility.
notice that those specific letters or calls from his wife were gonna be at issue that day?
Mr. Johnson did not, I guess, were you asking Ms.?
I'm saying that's Mr. Johnson's testimony that brought that up. Did Ms. King know to go and bring corroboration? And it seems there's a pretty good gap, and your opposing counsel pointed this out in their brief. Mr. Johnson has a right to his file and he has counsel. They could have requested that. What stopped them from being able to use any of it? Because it sounds like, a lot of just he asserts. And the trial court's supposed to accept that is what I'm kind of getting from what you're saying.
The trial court our position is the trial court, although she may take into account that he could have requested these things, she necessarily also needs to take into account that Ms. King had an obligation to preserve the records of these conversations that she's talking about. That she had an obligation to produce his file or make a reasonable effort to produce his file without, not just upon request, but at the termination of the representation. So in the moment where she's writing an affidavit for the government.
I don't think I understand that. What you just said. Why didn't Ms. King have any obligation to produce anything?
To furnish his file to him, not to the court or to the government
Had he
necessarily.
asked for her file?
That is not spelled out in the record.
If he had not asked for it, why did she have any obligation to turn over her file to him?
Your Honor, it is, and I want to cite appropriately the provision of, it's an ethical obligation, but professional rule, DC Rule of Professional Responsibility 1.16D, the obligation is to surrender papers and property to which the client is entitled at the end of the representation. And so then we've cited also DC Bar Ethics Opinion number 283. It says, at a minimum, the attempt to surrender the papers and property should include sending a letter to the client's last known address and waiting a suitable period of time, perhaps 6 months. Mr. Johnson wasn't difficult to find. He was incarcerated.
Well, what document? But I thought that we're talking about a document that doesn't exist.
I'm sorry. So now we're crossed a bit. The thing, I guess pardon me, I think this argument perhaps applies best to the letters that Mr. Johnson referred to in his testimony when he testified that he had mentioned after the lapse of his appeal.
You think the rule requires when he or his wife sends letters to his attorney, you think at the end of the engagement, the attorney had an obligation to turn over those send all those letters back to the client?
Not necessarily. I mean, Ms. King, when she found out that, I think, yes, these are included in his client file, his correspondence. I think it's very common practice among defense attorneys when the case is over, including at the moment when you find out you've become the subject of a claim of ineffectiveness, and you find out that the former client is represented by an attorney who is, pursuing that claim of ineffectiveness on the client's behalf, you can voluntarily just disclose the file to the successor counsel. I think transfer of files between current counsel or former counsel and successor counsel is very commonplace.
So this is not an ethical rule. You're saying that once she was sued, once there was a claim of ineffectiveness, usually we think of it as once there's a claim of ineffectiveness, the client has sort of waived any claim of confidentiality. And the defense attorney turns over material to the government. I mean, I guess it's true that did PDS ask for this material in preparation for the hearing?
He was not represented by a PDS attorney, so I don't know either way, but I'll leave it there.
See, my reaction had been,
I guess I missed something, obviously. My reaction had been that the government has a burden of production, perhaps. There are various burdens on the government, burden of proof, burden of production on various points. But she's just the counsel is just a witness and she doesn't have any burden of proof
With respect to
at
the
the hearing.
proceeding, sorry, Your Honor.
at the hearing.
With respect to the hearing, I think that logic may fly. The issue is the rules of ethics that the court has endorsed 1.16D. It's not, I don't want to harp on this
Yeah,
too much,
know.
but
All right.
it just, our position would.
If you don't want to harp on it, I won't pursue it either.
No, I would certainly like to answer all of your questions, Judge Glickman, but our position is that she, at the end of the representation, she had a duty to send it, send the records along or make a representation to Mr. Johnson that this is how you can get them. And
Does PDS do that when you have in every criminal case, when the case is over, you call up the client and say, here's your file, here's everything we have in your file in case you want it?
to some, I can only speak, I think, to my personal practice, and depending on how the case ends, we're inclined to yes.
Could you talk a little bit about the point you referenced in your intro about the failure of Ms. King to advise the client, which I think goes to the credibility question as well, your view of that scenario?
Certainly, Your Honor. And so we had sort of called this a second issue two, the failure to consult or advise as required under Flores Ortega, the Supreme Court's case. But even taking Ms. King's testimony at face value, the record shows pretty clearly that she failed to appropriately advise Mr. Johnson regarding the advantages and disadvantages of taking an appeal. And we cite her testimony just to set the scene for Your Honors. He goes to sentencing. The sentencing judge says, you have a very good attorney, and you can talk to that attorney about the possibility, the sort of merit to these various appellate issues that you might have. I encourage you to talk to your attorney about filing an appeal. Ms. King testifies that Mr. Johnson then doesn't want to file an appeal because he wanted her to focus on this other case, this felony assault case. She was, she says she was going to help him on the civil side of things with the custody case.
I don't think he said anything to her about, I want you to, I don't want you to take this appeal because I want you to focus on my child custody case or the civil matters. It was only the felony. And she told him that she wasn't going to be handling the felony.
She told him that she wasn't going to be handling the felony, but I do think it's still relevant that she said to him, she volunteered to him, I'm going, in this phone call where he supposedly confirms that he doesn't want her to pursue an appeal in this case. I was planning to help him on the civil side of his case with his custody issue. And consistent with that, intention, it's incumbent upon her to say, it's going to help you, or
This is an argument that's being raised for the first time on appeal. Is that correct?
that is correct, Your Honor. We think.
Why isn't it forfeited? Or in the sense that you have to satisfy plain error in order to get relief?
So we don't, Your Honor, we would say the plain error standard, this court hasn't applied it in the past, and this case doesn't really present.
I think we have applied it in the past. There's a case, for example, Ruffin. I mean, in many cases, we have, post-conviction appeals, and when counsel tries to raise a new issue on appeal from a denial of a quorum nobis or 23-110 proceeding, we, typically say you can't do it. You've got to bring it first in the trial court. And at a minimum, we've held that a case Ruffin comes to mind.
Ruffin.
At a minimum, we've held that plain error applies. And the two cases that you cite in the brief to suggest otherwise really are not holdings that you don't have to do plain error. The court just said there's no error here, period. So I think you've got to show plain error in order to, at a minimum, in order to get us to take cognizance of this issue. You think I'm wrong about that?
I apologize because my research didn't produce Ruffin, Your Honor. And if, I will accept as a premise that Ruffin stands for the proposition that plain error would apply in these circumstances. I think.
I think I'm citing the right case. Let me check my notes here.
Okay. But I
Ruffin
just,
v. United States, yeah, 25/8.
25/8
Third one, I think.
the last number, sorry. You said 25/8
Oh, one.
one, just number one. And so even,
Right.
yeah, right. Assuming plain error applies under these circumstances, the record, I think, speaks with sufficient clarity. Failing to remedy confusion about the appellate process is obviously deficient in a way that jeopardizes the fairness of the proceeding, as would be required for a finding of plain error. Maintaining the position we took in our brief and understanding that Ruffin contradicts it, could contradict it. We aren't making a blanket claim that anyone isn't, like everyone is entitled to. I'll take that back. Under these circumstances, given the way that the advice was presented to Mr. Johnson, and there's no, it seems supremely clear that Mr. Johnson was confused about what Ms. King was planning, or what role Ms. King might play in any ultimate appeal, especially given the statement that the sentencing judge made before, like right before the alleged conversation where he said all of these things about he wanted her to focus on this other case. And given those circumstances, Flores-Ortega implied an obligation.
Well, help me with that a little, because on one reading of it, he doesn't seem all that confused. He's like, okay, well, I'm gonna take the L on this misdemeanor. I've got the felony. I want you to focus on that. She clarifies that she's not focused on the felony, but she'll help him on the civil case. And I mean, I could see a scenario where maybe he doesn't really care as much about the misdemeanor because help me understand how it would affect his custody case if it wouldn't do anything until after he gets out of whatever sentence for the felony case, after whatever appeal for there, and the child is about to be 18, and so the custody dispute couldn't exist anymore for much longer. Sorry, I know that was a lot at once.
Yeah, yes, Your Honor. No, I think, so Your Honor's last point about the child aging out of custody, that would be a stronger point if part of counsel's decision not to accept Mr. Johnson's statement that he didn't want to pursue the appeal had not been based on her promise to help him with the custody issue. You sort of can't have it both ways. She's saying, I thought, her testimony is, I said I was going to help him with the custody thing on the civil side. Under those circumstances.
And she also said, right, that this would be one less conviction on your record.
One less conviction on your record. And to Your Honor's point about what he stood to gain from this, there are many things, all of which came out below. There is the sort of emotional stakes for him. He does not like these complainants. I think that's abundantly clear from the record. He is aggrieved by the fact that they've, in his mind, they've gotten one over on him. So he's incentivized to challenge, and that was something that counsel tried to bring out, but wasn't ultimately successful in doing because of one of the trial court's rulings on the evidence. He has this $150 fine. And apart from everything else, walking away from the conviction is, could be conceived of as a signal to his daughter. I'm willing to live with whatever the court suggested. And I think he would be in a much stronger position to play a role in her life, as he said at the sentencing hearing, was his intention to do, had he maintained his innocence and sort of fought to the end to protest that he hadn't said these words both about the complainants and about her, which is a very sort of scandalous allegation. So based on all of those things, I think she absolutely had a duty to advise him both as to what, the availability of counsel to pursue the appeal, that he didn't need to focus himself on it, that another lawyer would do it, that she would not be responsible for the misdemeanor appeal, contrary to what the trial court had suggested. the sentencing court had suggested when the sentencing court said, you have a great lawyer, talk to your lawyer about this appeal. And that, you know, that duty hinges on the statements that he made to counsel about his desire to waive the appeal. And so again, I would like to reserve 2 minutes of my time for rebuttal, and I will, but we ultimately would ask that you reverse and remand for entry of reinstatement of Mr. Johnson's appellate rights.
All right, thank you, counsel. We'll reserve your time for rebuttal. Mr. Goodhand?
Good morning, Your Honors. David Goodham for the United States. May it please the court. A couple factual questions that came up I just want to quickly address. There was some back and forth about the question of whether or not the defendant, Mr. Johnson, had asked the materials. The court at page 14 of the opinion makes note of the fact that, and this is Appendix 226, Mr. Johnson did not argue that Counsel King or the government had failed to produce materials he requested. Mr. Johnson also could have made a discovery request for copies of any materials he wanted. He did not take any of those actions, although his claim of ineffective assistance was pending before this court for 3 years. So this court actually took that into, the trial court actually took this into consideration. Another feature of the record that I want to point out relating to the whole issue of files, there was testimony about files at the hearing, and Ms. King was quite candid. This is page 74 of the hearing. You know, she was told by defense counsel, you know, there's a requirement you have to retain files for 5 years. And she says, oh, I still have his file. I have everything from his file electronically as well as hard copies. So again, you know, the trial court, I think, properly considered the fact that there was a full file waiting for Mr. Johnson if he had wanted to request his materials.
Ask you at the outset, when we don't have a lot of cases in this jurisdiction where we've made determinations about writs of quorum nobis. And appellant's counsel argues that the standard is clearly preponderance of the evidence, but you know, this is pretty extraordinary relief, a writ of quorum nobis at this stage. Should it be a higher standard of?
Yeah, from the government's perspective, yes. And I think the trial court correctly sort of reasoned this out. And the trial court's reasoning was this. Look, in the habeas context, 23-110, we're talking about a preponderance of the evidence standard. And it's fairly clear that's the case. The trial court then beckoned to this court's decision in Stevens and said, well, Stevens says there's a much more stringent standard for application of quorum nobis. So I take much more stringent and I look at preponderance for habeas / 23-110 and I say, well, much more stringent in this case context would likely mean clear and convincing evidence. And so I think that probably is a sound analysis in terms of burden and what the actual quantum of evidence is required. That said, I don't think there's any altering.
Does that conflict with Bangura?
I'm sorry?
Does that conflict with anything we've said in Bangura?
I don't think Bangura got into the weeds on sort of standards of production and what the actual quantum of evidence was necessary. Just to conclude, I'm sorry.
No, that was actually me, but if you want to conclude your statement, I can wait to ask you the question.
I was just going to close the loop on this point. I mean, we're not suggesting that in the context of findings of fact, you know, sort of the subsidiary facts that are the product of a hearing, that would have to be proved by clear and convincing evidence. I think probably the preponderance standard would apply there. But what we think the trial court got correct when she said the ultimate determination of whether or not the defendant has shown, for example, in this case, a fundamental error, a miscarriage of justice, that would be clear and convincing.
Okay, so taking you back just another step, would you also agree that in Stevens that statement, it's a one sentence kind of out of nowhere with no context or real explanation that leaves us to fill in a lot? And don't you think it'd be equally reasonable to view that as the standard itself, those elements that need to be proven as compared to any other, the 23-110, the Strickland, et cetera, are more stringent with what someone has to show in this context? Because I'm struggling to find a rationale why, if every other similar type of case we're doing preponderance of the evidence, why that wouldn't be appropriate here.
I think it's appropriate here because of what quorum nobis is. At bottom, we're talking about issues of finality. We're at the end of the road, if you will. The direct appeal has been exhausted. We're not talking about habeas anymore. We're talking about quorum nobis, sort of fundamental miscarriage of justice, error of the most profound sort. So in that context, I think clear and convincing evidence makes perfect sense. If you're going to come to court and say, okay, the Hail Mary has to connect, well, the Hail Mary should be adjudged by clear and convincing evidence. I'm sorry, I would point out, though, that we cite a number of cases in our brief that follow up on Stevens's point, where the exact language from Stevens, and I'm sorry, I don't have the exact page here in my brief, but we cite 3 federal cases that echo Stevens's
From out of
point.
our jurisdiction though, right?
Yes.
And I get that it's fairly undecided, but doesn't it also seem, I mean, I want to ask you a number of things and I'm going to try to limit it to 1 or 2, but doesn't it seem kind of patently unfair? It's like, okay, because we don't have you in custody right now, you now must forever live with these consequences without the same view. Doesn't that just seem really unbalanced? And then the second part to it relatedly, you know, I think the law, and for good reasons that other people have thought of that I must apply as a judge, sets the deck in prosecution's favor generally. And that promotes finality and other things. But if we're looking at things that are often going to involve circumstantial evidence, like this type of scenario, wouldn't clear and convincing evidence make it beyond a Hail Mary, like virtually impossible to connect that pass?
Not at all. I mean, honestly, you know, there's been a lot of discussion, for example, on my opponent's suggestion that this court that the trial court warped the holding of Bangura and had sort of a myopic focus on corroboration. I don't think the court got Bangura wrong by any stretch of the imagination. And I think the easiest way to analyze that is, I don't think there's any indication in the record that if the court had believed the testimony of Mr. Johnson at that hearing, the court would have granted quorum nobis. That is, if the court had looked at Mr. Johnson and Mr. Johnson, for whatever reason, his demeanor, he was weeping, whatever, his demeanor convinced that court that he in fact had asked Ms. King to file an appeal and he didn't get that appeal, the court would have said, okay, I'm granting quorum nobis. That's beyond clear and convincing evidence. So I don't think that's any, you know, I don't think that's a hurdle that's inappropriate here. I also, again, I think that's my core answer to the question that my opponent suggests is the overarching error here, which is that there was sort of a requirement, a legal requirement of corroboration on the part of the defendant, on the part of the trial court. I think the easiest way to answer that, in addition to considering what the court would have done if it had credited Mr. Johnson, is the easiest way to answer this is to look at the final paragraph of the court's opinion, where you can see exactly the court's reasoning. And this is at page 14 and 15 of the opinion, appendix 226. The court says, having the burden of proving the allegations, Mr. Johnson failed to produce sufficient evidence, nothing more than his own testimony, corroborating that he requested King to file notice. And then she goes on to consider his testimony. After weighing Mr. Johnson's testimony against the court records, the opposing witnesses' testimony, and the other evidence, the court finds his testimony to be not sufficiently credible. Ergo, Mr. Johnson has failed to demonstrate that his appellate rights were lost as a result of ineffective assistance. So what we have here is a court saying the only thing he came forward with was him sitting on the stand and telling me he asked her to file a notice of appeal. I am not corroborating that. I did not believe him when he made that declaration. And oh, by the way, there's nothing that corroborates that testimony that would have helped me get over the hurdle of credibility findings. So I think we have here, what I would suggest is, you know, the consummate exercise of discretion. We have a judge who recognized that there was a discrepancy on a key factual issue. Did he ask her to file the notice of appeal? Held a hearing, heard both from the trial counsel, both from the defendant, made credibility determinations based on that, applied the law correctly to that foundation of facts and that record, and ultimately concluded, you know, he hasn't met his burden. Final point I'll make, I think, well, two other points. There might be a academic discussion about preponderance versus clear error, but I think the opinion stands for itself when it says that she ultimately applied the lesser standard preponderance of the evidence. I don't think there's any doubt about that. So she erred on the side of caution. The final thing is there are many cases from this court that stand for the proposition that if you don't raise below an ineffective assistance of counsel claim in the 23-1 context, that you have forfeited on appeal. McKenzie stands for that proposition, 659 A2 838. Bradley stands for that proposition, 881 A2 640. Young stands for it, 639 A2 96. And if you can't bring up a new claim in a 23-110 context on appeal, then you certainly can't do it in the quorum nobis context. I think those are my sort of core points. Unless the court has any other questions, we would ask that you affirm the judge's conviction below. Thank you.
Thank you. All right, Ms. Collins?
Apologies, Your Honor. I did want to start by addressing some of the arguments that came up for the first time from the government about the standard that applies, the evidentiary standard that applies to writs of error quorum nobis. As we cited in our brief, we think United States versus Morgan, the Supreme Court case, stands firmly for the proposition that the preponderance standard is applicable.
I'm not aware of any case that suggests that clear and convincing evidence is required in the quorum nobis arena. Are you?
No, Your
I
Honor.
mean, when they talk about when those cases talk about stringent requirements and only the most serious, I think they're talking about not the standard of evidence of proof, but just the seriousness of the violation that justifies the remedy of quorum nobis. That's always been my understanding.
That's my understanding as well, Your Honor. And that being, I'll sort of cut short the dog and pony show, but I got
Now
up here.
here,
But
of course, the judge did say that even though I think maybe clear and convincing evidence is the standard, even under a preponderance standard, I'm reaching my results. So I don't think we have any reason to doubt that the judge, in fact, applied a preponderance of the evidence test.
we think the record suggests otherwise.
Because of your concern that she held, regarding regarding the importance of corroborative evidence.
Regarding the corroboration issue, I think her sort of singular focus on that belies the application, a straightforward application of the preponderance test. As to the issue the government is now raising, claiming that the separate freestanding claim of ineffectiveness has been forfeited. I wanted to point the court to a part of the government's supplement in support in their supplement. So the record, just a couple of points. The record amply allows for disposition of this claim. I think the court has discretion
I'm sorry, the record amply what?
The record is the facts relevant to this issue were totally explored below. And the government, up until today, hadn't argued.
No, they put it in their brief. They said you hadn't shown plain error. You hadn't shown any error, let alone plain error, which you're required to show.
That's correct, Your
And
Honor.
that's a reference to, I think, this is the plainness prong of the error, but
No, Your Honor is absolutely correct. I want to be careful to distinguish between plain error on the one hand and forfeiture, which I think we absolutely meet the standards for plain error.
oh, you agree that we have to look at the standards for plain error?
No,
Oh,
no, Your Honor, but assuming.
forfeiture is plain error. I mean, forfeiture.
Forfeiture, right, waiver would be. So I apologize, Your Honor, I'm confused, but if I could just briefly point the court to something that argues further in favor of resolution of this issue. The government had said that Ms. King had a clear and specific recollection of her advice and that this was a circumstance that bolstered her credibility. And I think given the way that the record is coming to the court, there's no sort of ambiguity that should hold back a decision on this point. And if the court has no further questions, we would ask that you remand for reinstatement of Mr. Johnson's appellate rights.
All right, thank you. We would like to thank both counsel for your briefs and arguments, and at this time, we'll stand adjourned.
All rise.